Good morning. Good morning. It's Thursday. It's April 27th. I can't believe it's the end of April. We've definitely got some April showers and weather. It's hoodie weather over here today. It's so good to see all of you. Today, we're really just covering like 3 or 4 different parts of one case. We are going back to Idaho to talk about the King Road murders or the Idaho University murders. It always feels weird to me to call them the Idaho 4 because it just, I don't know. It feels cheeky and it's a heavy case. I also don't want to use the defendant's name all the time because sometimes defendants, if they are the ones who did this, want notoriety, and that is not what I want to feed into. So in today's show, I'm going to be talking about everything that's going on with the surviving roommate. I got all of the documents from the court, not from Twitter. So we have a little bit more information than what I've seen shared, or at least than what I've seen shared. There might be more out there that I have not seen because I don't see everything on the internet, shockingly. Sometimes I try to, and it doesn't always go well for me. We are also going to talk about the writ that was denied and anything else that comes up. I'm going to leave a lot of time for Q&A because there's room for a lot of questions in what's going on, especially when we're talking about the subpoenas. And then I have not pulled it up yet today, but before we log off, I will go and see if we have any new information in the defamation suit between the university professor and the TikToker, just to make sure that we haven't missed anything, because these things tend to drop like while I'm streaming, and then I get done streaming and I'm like, what happened? So we're going to look for that too. And I'm waiting on a few more documents from the court. I'll see if those come in while we are streaming and then pull those up for you. If not, I will go back to what is on the internet. So with all of that, it's time to go. We need to just roll the intro and get ready to rock. Y'all ready? I'm ready. I'm looking for my intro. We're prepared. We're professionals here. It's time. Look, man, I am a little bit under the weather. I don't know if you can hear it. I'm a little congested. I'm a little just, but I've got my coffee. I've got a tankard of water. I've got my laundered hoodie. I'm ready to go. It's time for coffee and cursey words. And if you want to let me know where you're coming in from and what you're drinking while this rolls, it's always good to see you.
Hey there.
I did that wrong. But since I did that so wrong, replay crew, love you. Thank you. There will be timestamps down below.
Hey there. I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not. Let's get into it.
Now, I'm with Jessica. Jessica's like, I live in Idaho. I don't like the term Idaho 4. It just, I don't know. It doesn't humanize the victims. All of the law enforcement documents have been calling it the King Road killing because it is, or the King Road case, because that is the location of where the home was. And I think that makes it clear. We can't just call it Idaho because unfortunately, Idaho has a couple high-profile cases going on right now. But when I'm talking about Idaho, this is the case that I am talking about. And it's also hard to list out all of the victims' names. So I think we're going to just go with right now the King Road case, and then we'll go from there. But again, if the defendant is convicted and we start calling him by name, then maybe we will. But for now, I'm letting you know where I'm at. Might that change? Yes. That might change, and I will keep you in the loop on that. I see the chat talking about those who have recently passed away. We lost a moderator who moderated on a lot of the channels in this community, and I see all of the condolences there for Secret McSquirrel. I also see all of the condolences to Jerry Springer, and then also saw a super chat for a law nerd who lost their husband. And to all of you that are grieving, grief is a really funny and hard thing. And it's hard, but sometimes taking a moment to do something else will hopefully help. So Minnie Mercury, and to everyone else who is grieving, thank you for sharing with us and for being in community with us. I'm so sorry for the loss of your husband. That is a tremendously painful thing to go through. And you have a set of Weasley brothers too, which I absolutely love. So the community is here to lift everyone up and to take a minute Unfortunately, today is not a super light episode. Today's a heavier episode, but you can always go back and watch Food Court from Tuesday, because Food Court on Tuesday, can we all just go back to Food Court? Food Court is a favorite. So condolences and thoughts to all who are feeling it, because I know that it is a lot who are feeling it at the moment. So with all of that, we're going to move into a really heavy case. This case is supposed to be going to preliminary hearing at the end of June. We will see if it goes to preliminary hearing at the end of June. I think I'm going to talk about the subpoenas first and then circle back. I'll talk about the subpoenas first, and then I will go to the writ, and then we'll circle back if there's any more information, because the subpoenas are really what I think a lot of you have been seeing on the news and want to know about. The writ's a little more legally law. Is that a word? It is now. Emily, are you caffeinated at all? Nope. Just rocking cold medicine. So maybe it'll be good. Maybe we'll be like Dayquil Owens today. Maybe it'll be unintentionally hilarious and we're here for it. So let's do that. Chat, do you agree? Hopefully chat is on board. It looks like you are. So let's get into the stuff that's going on in Nevada. We should probably do a road so far for those of you that aren't following this case. I imagine that's a very small number, but let's do that. Let's do that. All right. As a quick road so far on the King Road case, this is coming out of Idaho. Brian Koberger has been arrested and is pending preliminary hearing for the murder of 4 University of Idaho students. And the case has garnered much national attention. There have been a lot of purported leaks in this case. I have covered it quite a bit. I get frustrated by things that I feel are misinformation. And I say I feel because that's generally my gut response. Is like, wait, that's not accurate. Clickbaity headlines and stuff that is just not quite accurate, especially when it comes to a case that has not gone to trial yet. That kind of speculation really just kind of puts me sideways, which is one of the reasons that I am covering this case, because there's a lot of information that we do know, and I'm going to lean into what we do know, so we know what is at least being shared in court documents and can start to grab what are the facts as we know them, and then how do we go forward from there, because there is an entire community reeling from what is happening. I think it's beyond a community, because internationally I've seen people reeling from the horrificness of this crime. And so to use it as clickbait does not sit right with me. And to also maybe give people, not hope, that's the wrong word, but information that is not accurate, going, that's the thing. We know we've got the person. Because one of the things that we as humans really want and desire deeply is certainty. I'm one of these humans too. You might be one of these humans too. I want to know. And the difficult thing with criminal law is that there is often an element of unknown. Why did this happen? Why did this happen to them? When things are senseless, they are that. They are senseless, and we don't know, and we don't have reason, and we don't have understanding. And it is very difficult to process that in our brains, because understanding why something happens gives us at least some sense of order in a world of chaos, because we are really just spinning around on a rock in space. But feeling like understanding why, even if the understanding doesn't give resolution, makes us feel better. And sometimes we're not going to have that early on, particularly in a criminal case. We're not going to know. It's one of the things that's really hard about the Murdaugh case. The why of it is very unsettling and very difficult, because most of us can't wrap our heads around why these things happen, because they are senseless. And so with this loss, we are going to lean into what we do know, and I am going to stay away from what we don't know. I covered some of those headlines in a previous Emily Show podcast. That's available here on the channel. If you want to see me legaling in. Somebody said legalese in the chat and it caught my eye. Legaling in, yes, legaling in. If you want to see me leaning into what we know and what we don't know. And that's where my coverage is, and that's what I try to do on this channel, so we can talk about the things that are at least put in court documents. They can be allegations and shade, but at least we know in the court documents, this is what's happening. So we're going to go to the subpoena first, and then we're going to go to the writ. Here's all the things going on surrounding this case. There is the underlying case. There are lawyers being hired in the case. There is a subpoena for an out-of-state witness that is one of the surviving roommates that we're going to talk about. There is a defamation case where a TikToker has said that they are a spiritual witness and that a university professor is the perpetrator of these crimes for a wide variety of reasons. Again, I think leaning into the clickbait and people want certainty. And that defamation case is ongoing. I've covered that a lot here. It's fascinating. And then there was a writ taken to the Supreme Court of Idaho by the Associated Press and a ton of other media outlets over the gag order, the non-dissemination order that is in place. So those are the 4 parts as I count them. The underlying case, the subpoena out of Nevada, the defamation case, and the Associated Press writ. There are 4 parts of this case that we are going in on today. All right, as I flail my hands around and run into my own water. This is going to be a very smooth day. I feel it in my bones. And by saying that, I say that it is, I am being facetious. So let's go on to the subpoena, because I saw a lot of things that troubled me with this. And again, this is one of the reasons why I'm covering this case. I am troubled that I have seen a lot of vitriol directed at their surviving roommates. These surviving roommates have been through a tremendous amount of trauma and pain and stress. Survivor's guilt is a very unique and devastating thing. And I've seen a lot of people speculating about this roommate's involvement, which is horrible. And a lot of other things that are completely unfounded. So as we go through these subpoenas, I hope that we clear up any perhaps misconceptions. And law nerds, I see you in the chat being like, that's horrible, WTF, because it's not y'all. Y'all aren't the problem. Y'all are the light spot on the internet. Y'all are hydrated. You have healthy boundaries. You drive well. You can parallel park. Y'all are the best. Some of you might not be able to parallel park. Asterisks, mileage may vary. It's not you, but it's the rest of the internet. And I've seen it, and it is horrible. Y'all are a bright spot on the internet, and y'all are unique for that. And I adore you. All right. Let us get into these subpoenas, but I have seen it, and it pisses me off seeing these survivors treated so badly. Most can't imagine what this type of pain is like. And I'm glad that you can't. Law nerds are very empathetic. The rest of the internet, maybe not so much. Okay, so I'm going to redact the first page of this because it has personal identifying information. But this, you're going to have to just trust me that we can do it this way. You're going to have to just trust me that this is what it is. But I always like to show you what it is because, again, we do things together. This is a show your work kind of a channel, so y'all know what we're talking about. Let's see. There, we want to do it that way. Hopefully that works for y'all. Actually, this way might be a little bit bigger. There we go. No, I'm doing that. This is a request for foreign subpoena for an out-of-state witness. With an out-of-state witness, it is very difficult. We saw this in Depp v. Heard. Remember when TMZ came in, or TMZ's lawyer came in and tried to block Spicy Draco, Morgan Knight, from testifying? Do we remember all of that? No, it is not. Yes, Morgan. There were 2 Morgans. Morgan Tremaine, not Morgan Knight. I've conflated my Morgans. Spicy Draco is Morgan Tremaine. When they were trying to block Morgan Tremaine from coming in and saying, is he responding to subpoena? Well, he was given a subpoena, but Virginia can't go to California and drag you into court in Virginia. They don't have the authority to do so. So they have to get a subpoena in the state where you are, because the courts in Idaho don't have authority over persons in Nevada unless they do more to gain that authority over the persons in Nevada. So in this case, the moving parties, and we're going to go through who that is and everything, in Idaho reached to Nevada and said, hey, we need to get a subpoena for this witness in Nevada. And the Nevada courts need to make sure that they show up in Idaho. People can show up of their own free will. They can be given a subpoena and show up of their own free will. But also, just being subpoenaed doesn't mean you have to go out of state. Federal courts are different. Federal. Welcome to the US. We have 1,000 court systems. Federal courts are different. We're talking about just the limited scope of state courts. This is quite a problem. This happens. I imagine this happens more in smaller states. And I imagine this happens in Nevada a lot when people get into fuckery when they're just there on vacation. In California, generally it was county to county issues because people didn't leave the state as much that I was having to deal with, but it did happen. When you deal with different countries, it's a whole other situation. We're not talking about that today. Oh, let me scroll. So let us go to page 2, so this is a motion from the defense attorneys seeking an out-of-state witness, that out-of-state witness being one of the surviving roommates. The surviving roommate had been initialed as BF. Their name is now everywhere in the media, and was found before that too because of social media. So I am going to go back and forth probably between her name and BF, but BF is the surviving roommate. And we saw that when we looked at the affidavits that they talked about the two survivors, DM and BF. So with that, having considered this is certificate of Idaho judge to secure the attendance of an out-of-state witness. Having considered the defendant, this is the defense making this motion. Let's see if I can make this a little bit bigger. There we go. That's just going to have to be the way for right now. Having considered the defendant's ex parte motion for a certificate to secure the attendance of an out-of-state witness and the affidavit of Richard Bettoni in support of said motion, the court being otherwise fully advised herein, I, Megan E. Marshall, do hereby certify as follows. I'm a magistrate judge for the 2nd District of the state of Idaho, which is a constitutionally and statutorily prescribed court. In this case, Brian Koberger is charged with 4 counts of first-degree murder, the Idaho case, which is punishable by death or imprisonment by life, and 1 count of burglary under the Idaho Code, which is punishable by imprisonment in the state prison for not less than 1 and not more than 10 years. I am the judge assigned to preside over the preliminary hearing scheduled to occur on June 26, 2023 at 9 a.m. through June 30th, 2023. That seems short. We'll see how it goes. That seems short. But for this, I mean, it depends on what the defense puts on. Bethany Funky Funk. I'm not sure if it's Funk or Funky. I'm not sure if you pronounce the E. I do not know. But BF may be a material witness for the defense in this case. For the reasons stated in the affidavit of Richard Bettoni, the presence of BF is required at the Latah County Courthouse, and then the address of the courthouse beginning at 8 a.m. on June 28th. So they're expecting that the defense will get into their case on June 28th and that the prosecution will be done with their part of the preliminary hearing by June 28th. So 26 and 27, so 2 days for the prosecution, and then 2 days for the defense. Under the laws of the state of Idaho, BF comes into this state in obedience of a summons requiring her presence at this hearing. She will not be subject to arrest or service of any process relating to matters that arose before she entered the state under summons. That is common language because you can't summon someone to a state under like a guise and then arrest them for something else. So that's not unusual. And then they certified this document. We're going to go on to the next attachment. And this is the ex parte motion in Idaho. This ex parte motion in Idaho has not been made public on the Idaho website. I grabbed this through the Nevada courts, which took a little bit more doing. Comes now Brian Koberger by and through his attorney, Ann C. Taylor, public defender, hereby moves the court for a certificate to assist in securing the attendance of BF as a witness. And then they said when. Exhibit 3 is the affidavit in support of the motion. This is the part I wanted to get into. I wanted to see the affidavit from the defense. I'm guessing that this individual is the defense investigator. They will probably tell us. This is a first I scanned this for personal identifying information, but I did not read through it because I wanted to read through it with y'all and go through it together. So this is this I am imagining is an investigator who is working with the defense. Again, not unusual. The prosecution has the, law enforcement branch that is working with them, be it federal or state or what have you. So the public defenders also have access to investigators that are hired through the public defender's office. All right. Let's keep going. I, Richard Bertoni, being duly sworn under oath, says, I'm a criminal investigator hired by the defense to keep reading, Emily, to assist in the representation of Bryan Kohberger. I was asked by appointed counsel to investigate the incident, which led to the arrest. Bryan is charged with 4 counts of first-degree murder, 1 count of burglary. The deaths took place in a 3-story home. There are 2 bedrooms on each floor, bathrooms on each floor, and a kitchen, dining, and living room on the middle floor. Kohberger is alleged to have entered the house around 4 a.m., while 6 people were sleeping/present, killing 4 people in 2 separate bedrooms. The people killed were located in 2 bedrooms, one on the 2nd floor, the other on the 3rd floor. BF's bedroom was on the 1st floor. The other surviving roommate's bedroom was on the 2nd floor. BF was interviewed by police on several occasions. She disclosed things that she heard and things she saw. BF was present at home 8 hours later when police were called, arrived on scene, and discovered the homicides. During the course of my investigation, it has become known to me that BF has information material to the charges against Kohberger. Portions of information BF has is exculpatory to the defendant. BF's information is unique to her experiences and cannot be provided by another witness. BF resides in Nevada, and it is necessary to subpoena this witness because the witness's testimony is materially necessary in this case. That is the part lots have discussed. And yes, we're going to get to what happened with this. In this coverage, but we need to get the underlying so we can talk about some of the misconceptions. So don't worry, we're going to get to what happened as of yesterday. So this was filed the 22nd day of March. The stuff got to Nevada this month, and then the motions in Nevada got picked up, I think, by the New York Times first. It could have been the New York Post first. I don't remember which New York did it first. Yes, I noticed that they misspelled the roommate's name half of the time in this affidavit. They left off the E on the last name. I wonder if that auto-corrected and they didn't even catch it. So they believe that some of what surviving roommate BF might have heard, seen, done, what have you, could be exculpatory to the defendant. Here's what they're going to want if they're presenting a defense. And most of the time, you don't see a defense at a preliminary hearing. A preliminary hearing is not a trial. It is a probable cause hearing, like plus, because you have live witnesses. The prosecution could put in the testimony or the purported testimony of BF through police. They don't have to call these witnesses, and they might choose not to. Now, again, they could subvert the entire process and just go to a grand jury. They did not do that in this case. It does not seem to be common practice in Idaho. It's common practice in other states to just go by grand jury. And so the defense isn't there at all. The defendant's not there at all. They get the transcripts later, and they do it by grand jury. This will be a public preliminary hearing. The defendant will be there. The defense attorneys will be there. Witnesses will be cross-examined, and they have more of an opportunity to get a sense for the case from the defense side. In the I guess calculus of strategy of how to put on a preliminary hearing, you need enough that the court binds over the defendant. And in a public case like this, you might want enough that the public understands so they stop asking questions, perhaps, but that would be an ancillary purpose. That is not the primary purpose. The primary purpose is to hold the defendant over, to answer for what he's been charged with, to go to trial. So it is to find probable cause that the person in custody did the thing. Oftentimes, there is not a defense presented unless there is a very strong affirmative defense. In a case like that would really be mistaken identity, a self-defense claim, things like that. what the defense is going to put on in this case is curious to me, unless they're going to, because if they're just attacking the evidence, that gets done on cross-examination and argument. So I'll be really interested to see what the defense puts on here. But they want to call this roommate to testify as called by the defendant. The prosecution's probably not going to call these live witnesses to prelim. They don't have to. They can just use the law enforcement officers, and law enforcement can testify under oath. I went to the house at this time. I talked to this roommate. This roommate said this. And all of you are going to go, Emily, that sounds like hearsay. Yes. Emily, is that allowed at a preliminary hearing? Yes. Officers, law enforcement officers can present hearsay at a preliminary hearing instead of having the live witnesses testify. And there are different strategies to that. And if you're curious about that, I can talk to that about when and how we would choose to have live witnesses at preliminary hearing versus not having the witness at preliminary hearing. And when I say live witnesses, I mean the witness in court not having their testimony presented through a law enforcement officer. But it can happen. Law enforcement can come in and say, this person said this, that person said this person said this, we arrested that person, this is what happened. And that's what a lot of preliminary hearings are like. They tend to be very quick. They generally don't take too long. Even on homicide prelims, they can take maybe a day unless there are some really, really quirky facts. So it's just a preliminary hearing. We probably won't see more than what's in the affidavit. So with all of that, the defense wants, so let's take a look at the motion to quash the subpoena before we go to what the court ruled on quashing the subpoena. Let's see. What I saw online was a lot of people saying, wouldn't this person want to come testify? Well, that's a lot of judgment on someone who's been through an unthinkable amount of trauma, but this isn't the trial. This witness's testimony is probably not needed for a preliminary hearing in any way, shape, or form. And so I don't know what the defense wants from this witness, but maybe we'll find that out later. Let me just double check this one and make sure that they don't have any issue. Oh, I saw a lot of questions scrolling by. Hey, Hoaglaw, good to see you. I saw a lot of questions scrolling by about wouldn't the misspelling of the name be an issue? The name is misspelled in the affidavit, so it wouldn't be an issue. It's spelled two different ways in the affidavit, so it's one of those things where it's like, well, it's not misspelled on any of the orders, but the court's not ordering this subpoena anyway, so it's kind of moo. It's moo, like a cow. Okay. Motion to quash foreign subpoena comes now. Kelly Ann Villoria, I think, counsel for BF, and respectfully moves to quash the foreign subpoena. The motion is made based upon the attached points and authorities. Always makes me think of Lincoln Park. All papers and pleadings filed herein. Memorandum of facts. On April 3rd, 2023, Evelyn Grosnick, interim Washoe, that's probably the wrong way to say this county. Washoe, maybe. County public defender sought and obtained an ex parte foreign subpoena. Sought and obtained an ex parte foreign subpoena. The subpoena was issued, which was issued April 11th, 2023. And purports to require BF to appear in the 2nd Judicial District of the Court of the State of Idaho, County of Latah, on June, but not spelled June, June, 28, 2023, spelling in original, sick, at 8 a.m. for the duration of the trial or when released by the court to testify in the above named case. Not a trial, this is for prelim. The items provided in support of this subpoena were an ex parte request for foreign subpoena, which contained the following: a certificate from an Idaho judge to secure the attendance of an out-of-state witness, the ex parte motion, and the affidavit. Washoe is pronounced wash-o. Okay, thank you. It's spelled shoe. It's like washoe. S-H-O-E. English is such a funny language. Wash-o. Why not just spell it wash-o then? Oh, why not? Okay, let's keep going. So the affidavit further claims that BF, whose name is repeatedly misspelled, I like that the attorney was like, and also fuck you. I closed my coffee. whose name is repeatedly misspelled. Yes. Yes, I did. Sometimes the brain fires on all cylinders. Sometimes it does not. We never know. Hi, Fred. Dude, please don't step on my keyboard. You're gonna. Okay. All tech problems are now courtesy of my assistant, Fred. Hi, buddy. Do you want to say hi? He wants to say hi to the chat. All right. I appreciate that. This is what I was looking for. I did not know. Thank you. Now we know Washoe County is for, I imagine, the Native American tribe there in Washoe. So thank you, chat. I appreciate that. All right. As so many names are, I didn't even think about it. Should have, didn't. I've been taken over. Thank you, Fred. Let's continue on. So the name repeatedly misspelled is something that they are pointing out. Has, quote, information material to the charges against Mr. Koberger, and they're saying, oh gosh, Koberger is spelled like hamburger. Oh gosh. So that misspelling is also in the original. They are pointing out that these misspellings are in the original. Portions of this information BF is exculpatory to the defendant. These statements are conclusory without support, and there is no further information or detail pertaining to the substance of the testimony, its materiality, or the alleged exculpatory information of BF, and why it would be entertained at preliminary hearing, which is a very, very good point. Very good point. Peachy Smile in the chat is asking, can we spell check the lawyers? You can always spell check the lawyers. Just know that I also misspell things. I have repeatedly misspelled things in the titles of my videos. I tend to not give them too much of a hard time because I don't even catch them. So Zoe said sick is really underrated lawyer shade. It is great lawyer shade. Isn't there Grammarly for legal documents? I don't know. Since Grammarly came out, I have never used it on legal documents, but there was, I mean, most of my documents were published in a variety of different word programs that also underlined things in red. The problem is with something like a name, sometimes it will auto replace them to a word that's not the name, and that becomes a problem, and people don't even catch it. So let's see. These statements are conclusory without support, and there's no further information, detail pertaining to the substance of the testimony, its materiality, or why it would be entertained at a preliminary hearing. Oftentimes, defenses are not put on a preliminary hearing. Moreover, the subpoena was issued by the clerk of court without hearing. No hearing has been set for, BF to address these concerns. This motion follows. So, hey, the clerk did this. The clerk just issued the subpoena. There was no opportunity for hearing. We want a hearing. Argument: the court should quash the foreign subpoena issued purporting to compel BF's attendance at the Idaho preliminary hearing in this case. Law. Fred, what are you trying to get to? Is this what you want? Is this what you want? Don't knock it off my desk because you're going to knock my mug off too. Here, go. It is yours. Be free. There was a ribbon on my desk. No, pesky ribbons. If you hear a loud crash, it is my cat. Because he did not jump off my desk. He is continuing to shenanigan. So the Nevada rules govern the procedure for securing the attendance of a witness to testify out of state. NRS 174.415 in particularly, this reminds me so much of Washington State. It felt like a Dewey Decimal System. Not all states do it that way. It's just too funny. 174.415 in particular addresses the process for summoning of a Nevada witness to testify in another state. Specifically, it requires the court to, quote, fix a time and place for a hearing before it can issue an order directing testimony in another state. The hearing is necessary to provide a venue where the judge, underline bold. Why underline bold? Because the clerk issued this subpoena. The judge determines that the witness is material and necessary, that it would not cause undue hardship, that is a big one, to the witness to be compelled to attend and testify in the prosecution or a grand jury investigation in the other state, and that the laws of the state in which the prosecution is pending or the grand jury investigation has commenced or is about to commence, and of any other state through which the witness may be required to pass by ordinary course of travel. Once the procedure is followed and that burden is met, then and only then shall the judge, quote, issue a summons with a copy of the certificate attached, directing the witness to attend and testify in the court where the prosecution is pending or the grand jury investigation has commenced or is about to commence at the time and place specified in the summons. In any such hearing, the certificate shall be prima facie evidence of all the facts stated therein. Moreover, there's no authority for an Idaho criminal defendant to summon a Nevada witness to Idaho for preliminary hearing. And this is a big part of this. Which he said, wait, the clerk issued this? Doesn't a judge have to? Yes, that's exactly what they're arguing. The clerk issued the subpoena, and they are now coming into court saying what you can't do is that. So don't worry, we'll have resolution by the end of this. It will be fine. My hair is tickling my face. This is one of the things about having shorter hair. It is. I am living for it, but also it is new. So moreover, there's no authority to summon a witness from out of state for preliminary hearing. Hogue law, if I pronounce Latin wrong, it's because my brain is spicy. Prima facie. Here's where all of my Latin pronunciations come from, how my professors said it in law school. So I am highly influenced by how my professors said it in law school. And most of my professors in law school were also, especially when it came to criminal, were judges where I practiced. So it just kind of is regional at this point. Everybody just, or at least that's what I see, is people pronounce things kind of regionally how they did in their law school, or at least that's what I think. It doesn't come up much, particularly in California courts, because California courts tend to not use a ton of the Latin terms. Also, it is now it's always been my thing that I pronounce things badly, but let's keep going. I'm still going with prima facie, but now I'm questioning myself. There is also no authority for an Idaho criminal defendant to summon a Nevada witness to an Idaho matter without a hearing. And there's no authority to summon a Nevada witness to an Idaho matter without a Nevada judge making a finding of materiality, necessity, and lack of undue hardship. The rule does not contemplate a Nevada criminal defendant's ability to subpoena a witness to appear before a court in Nevada. However, there is also a requirement for a hearing requirement there. Thus, even if the law applied by analysis, no hearing occurred and that important procedural requirement was not met. Additionally, the rule provides that if a judge of a court of record in any state, which by its laws has made a provision for commending persons within that state to attend and testify in this state, I'm not reading that whole rule. It has to be a material witness. It said that person belonging within a state is a material witness in such prosecution or grand jury. So they don't know about materiality, and that's what they're getting to. Importantly here, there was no certification by any judge of any court of record in any state, Nevada or Idaho, that clearly states that BF is a material witness in such prosecution or grand jury investigation. So they're saying that the underlying court findings aren't good. Hey, first, there has to be a hearing. Second, the findings aren't made. So this is marching through the legal analysis. It's very clear and good legal writing. I appreciate this motion. Marching through the different arguments and going, this one is wet, and this one is wet, and this one is wet. That's what I hear in my head from Death Star Cantina. But it's like, this is not met, and this is not met, and this is not met, and this is not met. And that is just going down to going down the road. Importantly here, there's no certification. A close reading of the certification purported to be from a judge. They're not even accepting that what came is from the judge in Idaho. They're like, it purports to be. We don't know. From a judge merely states that BF may be a material witness. This is insufficient under the law for this foreign subpoena to stand. Lastly, as this court is well aware, a preliminary hearing is limited to a finding of probable cause rather than reasonable doubt. Hey, it's like we were just talking about that. Which is the evidentiary burden at a trial. This is the same standard in both Idaho and Nevada, and I imagine everywhere else. And then they cite case law that says preliminary hearing is not a substitute for trial. For the purpose of preliminary hearing is to determine whether a public offense has been committed and whether there is sufficient cause to believe the accused committed it. Meh. A preliminary hearing is not meant to become a mini trial due to its limited purpose in deciding probable cause. Yes, but in high-profile cases, they are sometimes want to become mini trials. We might want to see a mini trial. These witnesses don't need a mini trial. These witnesses, look, for the surviving roommates, sitting in the same room with Koberger is going to be unimaginable for most. Don't make them do that twice. Don't. Do that once at trial. Only once. If absolutely necessary. Mitigating additional harm to the surviving roommates should absolutely be a consideration of the prosecution here. So at a preliminary hearing, am I calling these witnesses if it was me making this decision? No. No. The officers who took their statements can testify as to their statements. Look, I know it's medicine that says do no harm, but it needs to be considered here. They're saying exculpatory evidence is an issue for trial, which the documents presented misleadingly suggest the preliminary hearing to be. They did say trial, and it is not a trial. For all of these reasons, the subpoena served upon BF is improper. Accordingly, the court should quash the subpoena. Conclusion: the foreign subpoena was improperly issued. There is no component of the statutes followed in issuing it, and the court should quash the subpoena. Guess what the court does? The court quashes the subpoena. So the last thing I am waiting on is to see if we have the additional documents. I have found it in the minute order that the court quashed the subpoena and that there is a stipulation to an interview where BF has agreed to sit down with the defense investigator and have a conversation. They don't even have to do that if they don't want to, but they're going to. And that's what the latest as of yesterday is. If those documents come in before the end of court, I will pull them up, but I have also seen them on Twitter, so we are going to go there. The other things I've seen on Twitter are not always the full documents, which is part of why I make sure I try to get the full documents if I can. It is not always easy, but these do seem to be the full documents. These were shared by Mike Baker over on Twitter, national correspondent for the New York Times, author of 0 books. That's pretty funny. And these were shared by Andrea Burkhart. It's hard to tell who's a journalist anymore because they don't have blue check marks. Okay, enough of the blue check mark shade. It's been funny to watch the wildness going on. So this is again shared by Mike Baker. By Mike Baker. I love the handle. With regard to this case, this is a stipulation and request for order. Let's see. And this is again out of Nevada. Comes now Kelly Ann, I think I said Villora the last time, on behalf of BF and Evelyn Grosnick, interim Washoe County Public Defender, and behalf of defendant Koberger, and jointly stipulate that the subpoena issued April 11th, commanding BF to appear, shall be withdrawn or quashed. And the court ordered that it be quashed. It would have been quashed either way, but the court ordered it be quashed. And that BF should be released from the subpoena, meaning you're not going to get in trouble for not appearing because it's been quashed. The basis for the stipulation is that Bethany, through her attorney, has agreed to an interview with Idaho Defense Counsel in Reno, Nevada, in lieu of proceeding forward in the subpoena for preliminary hearing. Now, did BF have to do that? No. Will BF's attorney be there? Yes, I'm sure they will be. And They didn't have to stipulate to this. The court was going to quash it. That was a good motion to quash. There were lots of grounds to quash it. But I also understand it might be like, just come and have a conversation with me and we'll be done. Wendy, this is a great question. What do they mean by exculpatory? They mean that it can, it doesn't help me to say exculpate. It means that it can help exonerate the defendant, or it can go to a fact that is beneficial for the defendant. It is evidence that shows that they might not be the person who did the thing. So, Hogue, I also like to call it squashed. I say squashed a lot with quashed. The court, I think, would have quashed this subpoena based on that motion to quash. But it probably saves BF money and time by agreeing to it, not having to continue to go back to court. And I imagine the thing that BF wants to do, and this is just me speculating, is to stay away from this case and to heal. And to not be sitting in a courtroom with Brian Kohberger. So when they do this interview, what it will likely be, and I see that question being asked in the chat. No, Will Marie, Kohberger will not be present during that interview. So I'm going to answer a few questions on this before we move on, and then we'll get to more of them when we get to Q&A. No, this will be an interview between one of the defense attorneys, likely the defense investigator, the witness, and the witness's attorney. That will likely be the people that are in the room. It's not going to be like a deposition where there's a cross-examination. It is really an interview where they sit down and ask questions. Sometimes it can feel more like a deposition, but it's not normally as formal as that. Sometimes there will be a court reporter there if someone pays for it. Sometimes there will just be a recording device and it will be recorded. It just depends. Oftentimes, witnesses do not give these types of interviews to defense attorneys. Sometimes they do. And if this witness is just like, I heard what I heard, I remember what I remember, fine, I will just sit down and tell you if that means I don't have to go to court. Good for them. They didn't have to, but good for them. So, and again, her attorney will be there to step in and say she's not going to answer that. So I see conversation about my blue check status. I used to have a blue check. I do not anymore. May I have one again in the future? Maybe. I used to pay for Twitter Blue way back in the day. It's weird that the blue check has become some kind of a polarizing statement. I used to have Twitter Blue back in the day, and then all the benefits of Twitter Blue started changing. So then I got rid of Twitter Blue, and now I miss the undo button. So may I perhaps do that again? Maybe, because I typo badly. Also, they have successfully throttled all of my reach, but I don't use Twitter a lot, so I might. It's not really a statement either way. It's just I might so I can edit shit. But I was blue checked, and now I'm not. So, it was nice when I got blue checked because people were impersonating me on Twitter, and it was real annoying. And here's the problem. I'm going to tangent real quick, and then we'll get back to this. Here's the problem with not being verified on social media if you are someone who does work on social media. If you are not verified and other people try to impersonate you and DM your audience and do the rest of it, I get a lot of emails of like, is this you reaching out to me? And that always breaks my heart for people. I'm like, no, it's not me. Don't respond. Don't click the link. But if y'all go to say, hey, this is an impersonation account, the only time they let you put in an account that's being impersonated is if that account is verified. So that was the only reason I actually cared about verification, because you couldn't say this account's impersonating that person because they didn't recognize me as an account. And that mattered to me because I hate getting emails where people are like, wait, were you DMing me? This seems weird. You were asking for me to send you money. I'm like, no, it's not me. So this has just been I've been watching with popcorn as it all unfolds. That's where I've been in it. So with all of that, mayhaps I do it again. Yes, I do. I am verified on Instagram, Facebook, so you know that my page is me, and on my YouTube channels. So that. You were using undo last week. I was, and then it disappeared. The day after that, it all disappeared. It was all gone. So mad. Lisa, thank you. I don't know if I'm going to be doing that. I think I'm probably blocked from Spoutable. So yes, they quashed my verification, and I kind of only want it if I can Mace Windu it. But I might anyway, so I can have back my my undo button. I really did like my undo button. And the impersonators are hard, and I don't like people targeting our community. It really pisses me off. I'm just watching what happens on social media. Most of my communication with y'all is going to be on the community tab here on YouTube, where you know it's me. And even though people try to impersonate me here too, where you know it's me, YouTube is super responsive with that kind of stuff, and it's made it very easy. And then on our member spaces and on Instagram for now, and we'll go from there. We'll just see. We'll see what happens. So the court has quashed the subpoena. The roommate has agreed to sit down and talk. The misperceptions that I saw on social media was, doesn't this roommate want to help? Doesn't this roommate want to do this? And I thought that those questions for me felt very unfair, because being subpoenaed multiple states over, I don't know, don't geography me. Being subpoenaed out of your state into another state to show up and testify at a preliminary hearing where a defense may not even be put on is tremendously inconvenient, and it's improper. So when people are like, well, wouldn't they want to do this? They're not being called by the prosecution. The prosecution's not going to call them at preliminary hearing. They don't, or at least I suspect, I can't speak for the prosecution. I suspect, based on my background, training and experience, that they probably will not call the surviving roommates at preliminary hearing and just have law enforcement testify as to their statements, which is proper at a preliminary hearing. So this can feel intimidating to a witness. It can be traumatic to a witness. And it's not because they don't want to help find out what happened. There are a lot of legally proper reasons to do that. So, I understand why the roommate fought it. It was an improper subpoena. Also, dragging people across state lines is not something you want to do. So I saw the question in the chat, Christy Fox, wasn't she living in Idaho at the time of the crime? Yes, but is not living in Idaho now. So even if they were in Idaho then, they aren't in Idaho now, so you have to subpoena them out of state. So with all of that, I think that the internet can be the internet. I think it's tough, but people are assuming the worst. And I don't think that's fair to do. These roommates have absolutely been through it, and we will see what they have to say if this goes to trial. It is going to be hard enough for them to testify if this goes to trial. I don't know. I guess my opinions on this are really deeply informed by the fact that I've been in the room where you see witnesses confronting people who have murdered their loved ones, and I know what that's like for them. So I have a whole lot of empathy. And also, like, there's a whole side of me that just wants to protect people from that experience because of how devastating it can be. For some, it can be cathartic. Every human is different, but you can see it, and it's different. It's different than being on the internet and being like, wouldn't they do everything? We never know how someone's going to act, especially when they're traumatized. So no. Cheryl Reed, I did say if this goes to trial. After the preliminary hearing, this might not go to trial. Brian Kohberger's attorneys might go to the prosecution. This is, hear me, this is speculation. Depending on what happens at the preliminary hearing, if the prosecution were to take the death penalty off the table, could this plea for life? It could. It absolutely could. So that's a possibility. It can happen. There's a lot of reasons things could not go to trial, but it can happen. He could go into court and be like, Your Honor, what's your indicated sentence? And the judge would be like, life without parole. And he just pleads to everything and goes, okay, you sentenced me to life without parole. There's a lot of things that can happen. So I always try to say if, because it is not a guarantee. So with all of that, let us continue. But at the preliminary hearing, they might see it and be like, oh no, we're going to trial. But at the preliminary hearing, they might be like, oh, and these are the licenses of people that were in the, or these are the IDs of people that were in the home. And then it's like, I don't know how you go to trial on that, but maybe you have to. Because at the end of the day, depending on what the evidence looks like, there is a very real strategy about, then it becomes a strategy about punishment, depending on how the evidence comes out. And the strategy about punishment is different than a strategy about winning a trial, because it also could be that they plea on the guilt and go to trial on the punishment, which we've seen in other cases. And that's a possibility too. So when I say if it goes to trial, it's because we're a long way to go to get to trial, and there's a lot of possibilities there. So I try to be careful. I'm not always great at that, but I try to be careful with my language. So I try to help. Cheryl, you're welcome. I try to help explain. So when y'all ask questions in real time, it helps me explain better, and I appreciate you. It makes me a better streamer, and hopefully then we all know more. So thank you. So let us continue on. There was something else I was going to talk about. Oh, we'll do the writ, and then here, let me go look and see if there's any updates on the defamation case. And then we'll do the writ. And then I wasn't going to do this. Jamestown. BitBoy Crypto tweeted me his statement that he gave to the court. Should we just do that? We maybe should just do that. Legalese is hard, bro. It is. Legalese is hard, bro. Let me see and then I'll talk about Elizabeth Holmes next week. I haven't pulled the documents on that yet, but I'll do that next week. Where is my TikTok? You don't stop. Come on. Where is it? Emily, we can't sing that on the internet. Let's see. Let's see if there is anything new. We'll do a palate cleanser at the end of this case before we get to Q&A. Thanks, chat. We will. We're just going to keep scratching our heads. We're doing like a reverse quick bits. There's a decision. There's an order in the TikTok defamation case. Oh, we're doing that first. Y'all tell your friends. There is an order in the TikTok defamation case. Yes! That was not there last night. That must have just popped up either late or this morning. This is an order from yesterday. Oh, breaking news. We're doing it now. I don't think I have a good breaking news sound. Hold on. Let me download this order. Let's do it. This is what we're doing. I'm going to have to update my title. We're going to have to timestamp the shit out of this. All right. All right, I'm downloading. Let me go to Twitter real quick. This is what I will use Twitter for. We're going to just take a moment. I haven't seen this covered anywhere. All right. Should I call it breaking? It feels breaking. We're going to just call it, what's the rules for calling it breaking? My rules. We're just going to call it breaking. All right, y'all. Aren't you glad you're here live? Let me update. Give me 1 second. This is what I love about live streaming. Sometimes things happen live that you don't know are going to happen live. I'm going to update the title on our video real quick. And then we're going to go to this order. I'm excited to see what happens. Oh, I'm a little nervous. Let's see. Case, a gag order. All right. We'll talk about the new prosecutors that were appointed later. I saw that and I went, nobody cares about that. And then everybody ran to Twitter and was like, more prosecutors have been appointed. I'm like, do people really care? I guess they did. Okay. I'm breathing. All right. Oh, I should have included the link to the video. Damn it, Emily. This is why I need the undo button on Twitter, because I should have included the link and I didn't. That might have convinced me to buy Twitter Blue again. Okay, here's what's happening. Did that go? Yes. All right. I'm excited. I've been waiting for this ruling. I don't want to be disappointed. Okay. Let's go. Steal the sound from CNN breaking news. I don't know what the sound is. We have lots of sounds. There's lots of music here. When we get to Q&A, we're going to pick different music beds for our Q&As. But I might need a break. Well, let's see what we've got. I might need a breaking news sound. We've got a lot of different bumpers. We don't normally do bumpers for breaking news. We've got a DEF CON Red bumper. Maybe we need to make like a similar DEF CON Red bumper for breaking news. It doesn't happen. Amora asked, are we done with BF? Yes, we are. BF is going to sit down for an interview with the defense attorneys, and the subpoena was quashed. So excited. Okay, let's swoop and we'll do a quick road so far. All right. Okay. Breaking news. Let's do it. I'm ready. I don't like covering breaking stuff, but new court documents make me happy. So let's just go. Let's just go. There is finally an order in the TikTok defamation lawsuit. I don't normally invest deep emotions into stuff like this, but I'm kind of invested in this one. Not even kind of. That's a lie. I'm invested in this one. Why? Because I am just deeply invested. Here's the background on the TikTok defamation case. A TikToker accused a professor at the University of Idaho of all kinds of heinousness involved with the King Road murders, accusing the professor of perpetrating the murders, of being in an illicit relationship with one of the victims, of hiring people to commit the murders, of a bunch of other stuff. So the professor then filed a defamation lawsuit after sending multiple cease and desist. The TikToker went on for the cease and desist and was just like, I don't give a shit. So a lawsuit was filed. The TikToker defaulted on the lawsuit, failed to respond, and at one point wouldn't even accept service of subsequent court documents. And the note was, does not want. The TikToker is still representing themselves in pro per. A default was entered by the court, and then the university professor went for a default judgment in the $1 million plus range, saying, hey, a default has been entered. Give us the money and the judgment. The TikToker filed an answer, a motion to set aside the default, kind of, because again, they're representing themselves, and a few other motions. So what we've been waiting for is the court to rule with regard to the default. Is the court going to set aside the default? And what I've said in all of my coverage, and will say again, is that courts often will not let a default stand if there's reason to not let a default stand. And my worry was that this default was pretty short. It wasn't years long. It wasn't months long. It was a pretty short period of time. The court will often set aside the default, leaning towards it's better to allow this to be decided on its merits than to default by accident or something. However, the plaintiff professor, I think, did a really good job through lawyers leaning into, TikToker knew about this lawsuit and chose essentially a clout circus. I believe that's exactly what they called it, a clout circus over court, and went on and mocked it and made content about it and did all of it, but did not answer in court. When the TikToker did answer, They talked about the fact that they were defamed by the professor by filing the lawsuit. They like sued them for suing them and tried to bring a countersuit and an answer. So there's been a motion to set aside the answer because of court a default is entered. Until the default is set aside, the answer can't be entered, and a bunch of stuff about civil procedure. So as of 4/26 yesterday, there is now a decision. All right, everybody, I'm excited. Let's go, people. It's go time. It's go time. Let's see what this court has to say. Memorandum of decision regarding defendant's motion for relief from a judgment, defendant's motion to be granted access to PACER, which is going to happen, defendant's motion for default or plaintiff's motion for default judgment, plaintiff's motion to strike defendant's answer, affirmative defenses, and counterclaims to complaint. Pending before the court are 4 interrelated motions. Defendant's motion for relief from a judgment or order pursuant to 60B, motion to set aside an entry of default, defendant's motion to be granted access to PACER, plaintiff's motion for default judgment, plaintiff's motion to strike defendant's answer, affirmative defenses, counterclaims, etc. In the interest of avoiding delay, and because the court conclusively finds the decisional process would not be significantly aided by oral argument, these motions will be decided on the record and without oral argument. As discussed more fully below, the court will grant defendant's motion to set aside the entry of default, rendering plaintiff's motion for default judgment moot. Boo! The court will also grant defendant's motion for PACER access and plaintiff's motion to strike with leave to refile the responsive pleading. Your Honor, no! Consequences! Boo. But also, that means this case is not done, and we are going to get to hear a lot more of it. This is keeping in line with the court's interest in having cases heard on their merits. However, I thought if there was a chance, this one had a chance based on the actions. But this means we get a lot more motions. So I feel bad for the professor. I do. Because the professor is going to have to continue to deal with all of this. But it's weak sauce. But I also get it. The court's like, ugh. Yeah. So, do I understand? Yes. Am I bummed? Look, hold them accountable. However, they did strike the answer, so that means the defendant is going to have to file another answer and counterclaim, and that will be interesting. Oh, courts are way more lenient with pro se defendants. They're not supposed to be, but they are. Courts are way more lenient. This is where all of my feelings about this case are coming from. I feel so bad for the professor. All right, let's see what the court decided and why. Because at least now we're going to get a lot more. We're going to get a lot more in this case. So our coverage does not end here. So I guess that's the upside, is we're not done here. My toddler immediately repeated, Emily, Your Honor, no! It is. I feel, I saw somebody say cue the Vader no. I might need that clip. No! Because that's exactly how I feel. But all right. This is why I don't get invested in these cases. Because like what legally is probably going to happen and what I want to happen aren't always the same. Legally, this is probably what was always going to happen, but this is not what I wanted. I was like, if there's one that has a chance, it should be this one. Because Clout Circus, maybe we need a Clout Circus. Maybe we need Clout Circus t-shirts. I can see it with a little not a Ferris wheel. That's not what I'm thinking. The merry-go-round type wheels with the horses. If I say like they have at Disneyland, everyone's going to ask me about that case. I haven't read it yet. I don't know if I'll be covering it. Let's see what the court has to say. Shall we? Maybe there is some very interesting shade in here. How long is this? Oh, it's 11 pages. Buckle up, y'all. This is what we're doing right now. All right. Background. This case arises out of the tragic murder of 4 University of Idaho students in November 2022. Plaintiff professor is a professor at the University of Idaho. I'm going to keep calling them the professor and the TikToker. It's just so much easier for me. A carousel. Thank you. Words are hard. Words are hard. Legalese, maybe not so much, but words are hard. Oh, that's true. Hogue, thank you for being the rational friend. I could just do the audio. Probably. Maybe. You are a rational friend. Thank you, Hogue. We all need friends like Hogue who bring us back down to earth when we're like, this is a great idea. It's like, no. Professor alleges that despite never meeting the students or being involved with their murders in any way, defendant TikToker posted sensational TikTok videos falsely claiming that professor had an inappropriate romantic affair with one of the victims and then ordered the murders. In turn, plaintiff brings 2 defamation claims against defendant, one premised on false statements regarding plaintiff professor's involvement with the murders themselves, the other premised on the false statements regarding the romantic relationship. Relevant to the at-issue motions, plaintiff filed her complaint on December 21st, 2022. 6 days later, defendant was personally served in Houston, Texas. Defendant never responded to plaintiff's complaint by the January 17th, 2023 deadline. See FRCP 12A1A1. A defendant must serve an answer within 21 days after being served with the summons and complaint. As a result, pursuant to Rule 55A, plaintiff moved for an entry of default on January 19th. I mean, there was a 2-day window. A clerk's entry of default was then entered and mailed to defendant on January 27th. On February 16th, defendant filed her motion to set aside the entry of default. Apparently anticipating that the entry of default would be set aside, defendant also filed her answer, affirmative defenses, and counterclaims. Presumptuous, or just representing themselves and not knowing, alongside a motion for access to PACER. Plaintiff responded the next day, opposing defendant's efforts to set aside the entry of default, filing a motion for default judgment pursuant to Rule 55B2. Plaintiff's motion to strike followed on February 27, 2023. Each of the pending motions is ripe for the court's consideration and resolved below. This is a great lesson in civil procedure, anyone studying for the bar. This is a great, just clean walkthrough of civil procedure. Thanks, Judge. Thanks, Judge. Analysis, defendant's motion to set aside. Legal standard, the court may set aside the entry of default for good cause, and it may set aside a final default judgment under 60B. An entry of default is a technical formality. A plaintiff must merely show, by affidavit or otherwise, that a party against whom judgment for affirmative relief is sought has failed to plead or otherwise defend. Therefore, setting aside an entry of default under Rule 55 is simpler and more straightforward than setting aside a default judgment under 60B. Whether to set aside the entry of default is a matter of discretion. I know! And we were hoping that Clout Circus would have persuaded you. The court is not persuaded by the Clout Circus. Also, pro per. When it's a matter of discretion. Let's see. See also Wright Miller Kane Federal Practice and Procedure. Quote, the different treatment in Rule 55C of the default entry and default judgment frees a court considering a motion to set aside a default entry from the restraints of 60B and entrust the determination to the discretion of the court. This is completely at the court's discretion. Completely at the court's discretion. In determining whether good cause exists to set aside an entry of default, the court must consider 3 factors. 1, whether the defendant engaged in culpable conduct that led to the default. 2, whether the defendant had no meritorious defense. And 3, whether setting aside an entry of default would prejudice the opposing party. They're going to find no prejudice. They're going to find that defamation cases are hard to win, and let's see about the culpable conduct. The standard is disjunctive, such that a finding of any one of these factors is true is sufficient reason for the court to refuse to set aside an entry of default. Any one of them. I love the way the court used disjunctive. I'm personally disappointed in this ruling, but I love this judge's writing. Ray, this is my biggest concern. I did not coin Clout Circus. The plaintiff's lawyers did. I believe that's what they called it. They might have said social media circus. I think they said Clout Circus. We'll go back and look. The defendant, as a party seeking relief from the entry of default, bears the burden of showing these factors favor such relief. Crucially, however, judgment by default is a drastic step, appropriately only in extreme circumstances. And that's the problem. A case should, whenever possible, be decided on the merits. And this is what I was talking about at the beginning. Courts do not like defaults. Is this a drastic circumstance? No. Did they answer within a month? Yes. I want to spell disjunctive like dysfunction. I agree with you, Hogue. It should be. Motion to make it so. And like dystopian. They all should be spelled with Y's. Good cause exists to set aside the January 27th, 2023 clerk's entry of default. Tell us, culpable conduct. There are two lines of cases within the Ninth Circuit regarding the standard for culpable conduct. One line of cases holds that a defendant's conduct is culpable if she has received actual or constructive notice of the filing and intentionally failed to answer. I think there's an argument for that here, though. We saw the TikToks. And then quoting Allen, in this context, the term intentionally means that a movement cannot be treated as culpable simply for having made a conscious choice not to answer. Rather, to treat a failure to answer as culpable, the movement must have acted with bad faith, such as an intention to take advantage of the opposing party, interfere with judicial decision-making, or otherwise manipulate the legal process. Well, they're not going to be able to show that. They're going to show that it was ignored, but they're not going to be able to show that it was an intention to take advantage. They're not going to be able to show that. Courts have typically held that a defendant's conduct was culpable for purpose of the good cause factors where there is no explanation of the default inconsistent with a devious, deliberate, willful, or bad faith failure to respond. The defendant did line out that they are representing themselves, etc., etc. I don't think the did not want is going to be enough here. Your Honor, I suggest that the test should be that the default should stand if it is more hilarious to do so. Agreed. And also, they went on to TikTok and flouted that they weren't taking this seriously, they couldn't be sued. But then in their filing was like, life is crazy and I'm representing myself. A second line of cases suggests that if the defendant has received actual or constructive notice of an action and fails to answer, that conduct alone indicates culpability. That one, Your Honor, we picked that one. Can we pick option B? Which standard does the court pick is more relevant than what standard we pick, but option B. Application of this more lenient standard for finding culpability hinges on the legal sophistication of the defendant. There we go. Holding that it's possible to reconcile the language in franchise holding 2 with the standard in TCI group when considering a legally sophisticated party's culpability in a default, and understanding the consequences of actions may be assumed with it intentionality. Here, the defendant is representing herself pro se and is not a lawyer. So the TCI group standard applies. It is sufficient to observe that Massell is not a lawyer and that he was unrepresented at the time of default. Accordingly, the proper standard to apply was the stricter standard. So the stricter standard applies because this is a legally unsophisticated defendant. Defendant's explanation for failing to timely respond is that she has been, quote, overwhelmed with multiple civil actions and responsibilities. Defendant specifically references how she is, 1, is contemporaneously representing herself pro se in a Texas court action. We haven't pulled that one yet. 2 is the custodial parent of a child whose father is away on military orders. 3 is the local next of kin to a family member who was in the hospital and on life support. 4, recently feared for her and her family's safety following multiple attempts by someone to enter her apartment illegally, which is totally fucked, by the way. And again, I am assuming these things are true. Chat's going to be like, Emily, you can't assume they are true. They are affirmed by affidavit and legal filing. I am assuming for the purposes of this that they are true. 5, suffers from emotional distress as a result of plaintiff's claims against her. I'm less persuaded. 6, suffers from combat-related PTSD. I am more persuaded by that, which impacts her ability to finish tasks when under stress. According to defendant, these circumstances collectively diminished her ability to effectively handle all of the responsibilities. And that is where the court is going to say that is enough to meet the standard. The court takes no position as to the genuineness of these claims. I should have just said that. The Emily takes no position on the genuineness of these claims. That's better language. That's better. Your Honor, thank you. I'm borrowing that. but acknowledges plaintiff's counterargument thereto. The defendant continued her publicity-seeking commentary about plaintiff's alleged involvement in the murders even after being served with the complaint. The reality is defendant spent her time posting at least 100 videos on TikTok, writing 3 blog posts, talking to reporters, recording a 40-minute YouTube video, and interacting with viewers in the comment section. If she had spent that time putting those defenses into an answer instead of boasting online to get more clicks, she could have filed a timely response. I did live for the sass of these lawyers. I did. Footnote 1. The court has reviewed the available postings referenced by plaintiff's briefing. Though off-putting and ill-advised, they reflect defendant's intention to defend the case. They are both off-putting and ill-advised. Okay. I'm happy to see more of this judge, even though I'm disappointed in this ruling. I'm happy to see more of this judge. They are both off-putting and ill-advised. They are fuckery. Fuckery can be both off-putting and ill-advised. Instead, the court accepts defendant's account for the limited purposes presented here, and that's going to meet the standard. Doing so reveals that the defendant's attempted failure to timely respond to plaintiff's complaint was most likely an unintentional oversight caused by self-serving carelessness explained by defendant's pro se status and confirmed by her relatively prompt attempt to set aside the clerk's entry of default once alerted to it. Footnote 2. The court mailed a copy of clerk's entry of default to defendant on January 27th, 2023. Defendant, however, states that she was only made aware of plaintiff's motion for entry of default on February 10th, 2023 in a telephone call made with court staff. Defendant's memorandum. Defendant then mailed her motion to set aside entry of default on or around February 14th, so 4 days later. To the extent defendant complains that she was not originally served with plaintiff's motion for entry of default, she is incorrect. Rule 5 provides an explicit exception to the service requirement. In such instances, no service is required on a party who is in default for failing to appear. Whether that's fair or not is another discussion. Although the court does not condone such conduct, another footnote. Defendant represents that going forward, she, quote, will prioritize court rules, orders, and actions and file timely motions. Defense memo. The court intends to keep defendant to her word. Oh, that's a pretty strong warning from the court. The court intends to keep defendant to her word. So this is a you have one chance counsel. And why do I say counsel? Because she's representing herself. She should have asked her lawyer when she needed to file the response. The court does not condone such conduct. Without more, it does not amount to bad faith with an intention to take advantage of the opposing party, interfere with judicial decision-making, or otherwise manipulate the legal process. As a result, it cannot be said that defendant engaged in culpable conduct that led to her default. This factor, therefore, weighs in favor of setting aside the default. Meritorious defense. I'm very interested to see what the court says about this. A party seeking to set aside entry of default must present sufficient facts that would constitute a defense. But the burden is, quote, not extraordinarily heavy. It's like meh. It's a meep of it's a LaCroix. It's a whiff of a burden, noting that the minimal nature of the burden the moving party is supposed to carry. All that is necessary to satisfy the meritorious defense requirement is to allege sufficient facts that, if true, would constitute a defense. If true. The question whether the factual allegation is true or not is true. I'm going to have to do that again. The question whether the factual allegation is true is not to be determined by the court when it decides the motion to set aside the default. Rather, the question would be subject of later litigation. Here, the very nature of plaintiff's claims against defendant presumes the existence of certain possible defenses. Right, as I said earlier, defamation is hard. That is, to prevail on a defamation claim in Idaho, the plaintiff must prove that 1, the defendant communicated information concerning the plaintiff to others. 2, the information was defamatory. 3, the plaintiff was damaged because of the communication. Truthful statements and personal opinions in certain situations are not defamatory in the first instance. Defendant unsurprisingly takes this position in her proposed answer, affirmative defenses, and counterclaims. Footnote 4. What's a footnote? Defendant filed her answer affirmative defenses and counterclaims after the clerk's entry of default. Entry of the default technically cuts off the defendant's right to appear. And then it cites a case providing the following example: defendant fails to answer or otherwise respond within the requisite time period. Plaintiff requests the entry of default and entry is made. Defendant then seeks to file an answer. It is too late. The court will not accept the answer of the filing. Should the clerk do so, the court will order it stricken. The only procedure available to the defendant is to file a motion to set aside default under Rule 55C, or seek a stipulation from plaintiff's counsel to set it aside. Nevertheless, defendant's filing, though premature, is instructive on the instant issue. So the court considered it even though it was supposed to be stricken, considering the defendant's proposed answer to resolve whether the defendant has sufficiently shown a meritorious case. So the court considered the answer for the purposes of this motion, even though it's being struck. Okay. I mean, all right, Your Honor. The defendant generally submits that the plaintiff's complaint fails to state a claim upon which relief can be granted, while also indicating her alleged defamatory statements are true or otherwise not actionable. She did. She asserted TikTok privilege. Do you remember the TikTok privilege? I'm surprised the court didn't put that in a footnote. Put the TikTok privilege in a footnote. Importantly, defendant did not conclusively establish the validity of these defenses right now. Clear. At this stage of the proceedings, the court only determines whether defendant has alleged defenses that, if true, should be decided on the merits. Again, not whether those defenses are once and for all meritorious as a matter of law on the record. The court finds that defendant has satisfied the meritorious defense requirement, keeping in mind the admonition that a case should, whenever possible, be decided on the merits. This factor is in favor of setting aside the default. Prejudice to plaintiff. To be prejudicial, setting aside a default must hinder plaintiff's ability to pursue her claim. Delay alone is not enough. That's not going to happen here. So we're going to skip the reasoning on that. That's just not going to happen here. Because the January 27th clerk's entry of default is set aside. Oh, let's do the conclusion paragraph. Plaintiff states she has suffered harm enough from defendant's antics, deserves the finality of the defendant's decision not to assert timely defenses, and expresses frustration over defendant's disregard for procedure and deadlines. These are understandable reactions under the circumstances, but plaintiff does not actually explain how she would be hindered if the default were set aside, because legally she's probably not hindered. To be sure, other than now being forced to litigate on the merits, there is no prejudice, especially when the action remains positioned at the very early stages of litigation. This factor, therefore, weighs in favor of setting aside. I like that the court was like, I understand. Like, I get where you're coming from, and you're not wrong, but also you're not harmed. You're not prejudiced by a delay of less than a month. Having found that the defendant is not engaged in culpable conduct, defendant has alleged meritorious defenses. And again, the court is not ruling on the merit of the defenses, just saying they've said it's not true, and that is enough for this very low LaCroix of a standard. It is just barely a hint of flavor of a standard. And setting aside the entry of default would not prejudice plaintiff. Good cause exists to Rule 55C to set aside the January 27, 2023 clerk's entry of default. Because that's been set aside, a clerk's entry of default against a party is the first of two steps required to seek an enforceable default judgment. They're going to set aside the default judgment because it's now moot. The first step, entry of default, is a ministerial matter performed by the clerk, and is prerequisite to later default judgment. Because the court has set aside the clerk's entry of default, the motion to default judgment is moot. Defendant's motion for access to PACER, they're going to get access for PACER. Plaintiff's motion to strike. Following the January 27, 2023 clerk's entry of default, defendant filed her answer, affirmative defenses, etc. Plaintiff moves to strike the pleadings as both untimely and procedurally improper because of the clerk's entry of default. That's true. As stated above, the court cannot accept and consider defendant's pleadings because they were filed after the entry of default. Defendant's answer affirmative counterclaims are stricken. Footnote 5. In a hyper-technical sense, In a hyper-technical sense, defendant's motion for CM-ECF access arguably should be rejected for the same reasons, but considering the unopposed nature of the relief sought herein, coupled with Rule 1's direction to constitute and administer rules to secure just, speedy, and inexpensive determination of every action and proceeding, allowing defendant to utilize the court system makes practical sense given its procedural rather than substantive implications. I love that the court was like, let me just be real clear. Real clear of what it is. So that is allowing this party to have access to the online filing system. This is really a just technical matter that they just need to sign up for. I don't know if they're pro se, if they get free documents, they might get them, they might get access to them free. Based on the foregoing, it is hereby ordered that defendant's motion to set aside entry of default is granted. Plaintiff's motion for entry of default judgment is moot. Denied is moot. Defendant's motion for CM-ECF access is granted. Defendant's permitted to electronically file and receive materials via the court's program for the purposes of this action only. Defendant shall follow all rules. Defendant shall immediately contact the court's clerk for instructions on how to request access within the District of Idaho. Plaintiff's motion to strike is granted. Defendant shall formally respond to plaintiff's complaint within 21 days of this memorandum decision in order unless otherwise ordered by the court. So 21 days, TikTok, you don't stop. 21 days, there needs to be an answer. And when there's another answer, guess who's going to be covering it? This girl. I will be covering it. I cannot with this case. It is wild. I need to know what under the law a spiritual witness is, because that is what has been asserted. This TikToker has asserted that their claims are true and they are a spiritual witness to the murders. I need to know more about that. And the judge did it's good writing with a little bit of sass. So it's going to be a really interesting case to follow. I just want to see the courts drop the hammer a little bit more, shockingly, when it comes to fuck around and find out. Is that in the best interest of justice here? Probably not. But am I offended by this case? A little bit. If I were the judge on the case, would I have done the same thing? Probably. I probably would have done the same thing. Because that's the judicially proper thing to do. But as a commentator, I got my feelings. And that's why I tell you where my feelings lie versus where what the court is doing. And in most cases, I'm just like, let's see what the court does. This one, I feel so bad for the professor. I truly, truly do. But when somebody is representing themselves, holding them to a default that was entered within a couple days of missing a deadline is practically not going to happen. Lacey asks, how do you become a spiritual witness? Is there a course on that? Apparently, you just need to be a TikToker. Raya said, lots of fuck around, no find out. That's where we're at right now. We're like all bun, no burger. All right. We have been streaming for like an hour and a half. I'm going to talk really briefly about the Ritz, and then we're going, not the like hotel or the cracker, the Rit, W-R-I-T. We're going to talk about the Ritz and go from there. Animal cookies. How do judges set aside their own moral outrage? Practice. And that's why we saw a footnote saying that it was ill-advised, saying that, what did the court say exactly? Let me pull that back up. I need to write it down. The court says it was off-putting and ill-advised. The court made a note of how they felt about it. Off-putting and ill-advised. But at the end of the day, you apply the facts to the law. And this is something people struggle with in law school, and you can see it, is that the morality, legality bit can be more of a struggle. You get practiced with morality, legality, and putting it aside and being like, I don't like this result, but I understand the legal side. My mom and I grappled with this a little bit, or a lot bit. After 9/11, my mom had been working for United. It's a long story for another day. But a lot of the airlines, United included, went into bankruptcy and fucked everyone that worked for the airlines retirement. And my mom and I had a really long conversation about morality, legality. How is this right? Well, morally, it's not right, Mom. It's fucked. But that doesn't make it illegal. Under bankruptcy law, this is allowed. But is it immoral? Is the morality of the thing fucked? Yeah, it's fucked. The people who worked for 30 plus years are eradicated. Yep, fucked. It's fucked. It's not moral at all. But is it legal? Yes, it's also legal. And that's hard. Does my mom still work for them? My mom is now long retired. My mom retired after 9/11. That was the end. That was it. But it happens. And it happens when people go into bankruptcy. It's not just that. That was my close contact with having to have these conversations in my family of, just because it's not right doesn't mean it's not legal. And that's a really difficult thing for people to grapple with. And then with lawyers, you start to learn to split your brain a little bit into what's the legal side of this and what's the moral side of this. And it can be hard sometimes when you put the morality really far aside. You see lawyers doing things where you're like, how the fuck did you get here? And I think it's because some lawyers split way too much or didn't have any morality to begin with. I think that's a real question. Like, how does someone like a Tom Girardi end up so far down the rabbit hole? Hi, Dr. B. What's up? You're looking handsome.
Well, thank you.
I'm streaming. What's going on?
I know you're live. I would not come in and I would not...
Well, you're going to have to come and explain to the law nerds now. Like, what's going on?
I would not come in and interrupt, but I do need to say that I have to leave.
Okay, bye.
The drywaller is finishing upstairs.
Okay,
He's
great.
got about 10 more minutes.
Okay.
I think you're telling me to leave now.
No, it's good.
Oh, okay.
You're just letting me know the things.
Yes.
Now everybody knows all of our business.
And I'm taking the
You're
Black
taking my
Pearl.
car?
Taking the Black Pearl.
Don't take my car.
You're going to be working all day. You don't need it. I'm taking the car.
As if there was anything I could do to stop him. Bye, hun. All right, let us continue. Dr. B is taking my car. Aren't you going to Costco? Shouldn't you take the bigger car? Yeah, aren't you going to Costco? Shouldn't you take the bigger car? No. Yes. No. All right, bye. The chat says you look good, honey. He's very sweet. I tried. It's not true though, because my car has equal storage and he is going to Costco to get stuff for me. So it's fair. Mine is more fun. Look, we're in that weird place. We're in that weird place where we're waiting for someone to be a teen driver. And so we need another car. But until T is driving, it doesn't make sense to get another car. Like it's just that strange space in life where it's like, we're ready for another car, but he's not driving yet. Thanks, Hogue. It is diplomatic. He totally took the car. All right. What was I saying? Morality, legality. Sometimes it's difficult, but it's also, these are the mental exercises you have to go through in everything. When you are, when you find the outrage in something, it's also trying to find like, okay, what's the law happening? And then how am I feeling about it? And know how you're feeling about it. And then look at what the law is. And then deciding if the law needs to change. Right. And just trying to deal with that. So that's a lot of what we do. And we learn in law school to do it. Some people had a real hard time with it. They're like, but it's not fair. And I'm sitting in law school going, what does fair have to do with it? This is law. Get off your, it's not fair. Let's look at the law. Sometimes the law is not fair and then you change the law, but don't sit here and start bitching about it for 30 minutes. We've got class to do. Like, let's go. I was much more of that kid in law school. Like, can we stop talking about the morality of the thing? Because you address it and then you move on. But there were people who wanted to process that more out loud. And I was like, yeah, it's law. It's law. It's different. It's not necessarily moral. All right. With all of that, let's keep going. Let's see. I also, Runkle said, I also believe in punishing wage theft with criminal charges. I mean, I can see it. Some judges really have a hard time with it. That's why I like to take it up with Congress. Take it up with Congress is really what it is, right? It's like, okay, let's have better lawmakers. I mean, that feels like a really difficult goal right now. Can we have different lawmakers that do that? Please. With all of that, let's talk about this writ real quick. I saw Hogue make a joke that I'm putting on the writs. We're going to put on the writs right now. We are going to put on the writs right now. Let's do that. We've got a long show today. We've got a lot to talk about in Idaho. So this writ was taken with regard to the gag order or the non-dissemination order that exists in the King Road case in Idaho. The writ was taken, and I did this another day where I listed everybody. The Associated Press et al. So a whole bunch, ABC, Society of Professional Journalists, all of the media. The media took a writ saying, Your Honor, this is violating our rights, and you should overturn or yeet the court's order with regard to the non-dissemination order. You should get rid of the non-dissemination order. Just be done. So with that, the court has issued a ruling in the writ denying the writ. That means that for now, the non-dissemination order stands and the petitioners have to go back to Idaho and deal with it, or back to Idaho. This was in the Idaho Supreme Court, back to the local court and deal with it. You can't, you don't have to go home, but you can't stay here, is what it is. So this is the order from April 24th. A lot has happened in this case, right? Let's continue on. A coalition of, this is from Justice Moeller. I'm just pronouncing that like the tooth because Dr. B was just in here. A coalition of media companies has petitioned this court invoking its original jurisdiction to seek a writ of mandamus. God, we are having a civil procedure class today. To seek a writ of mandamus and a writ of prohibition to vacate a non-dissemination order issued by a magistrate court in the pending criminal action, State of Idaho versus Brian Koberger. This court expedited the case and order briefing from the parties. We have also granted motions to intervene filed by two parties in the case, the State of Idaho County Prosecutor and the defendant, Brian Koberger, who are also permitted to file briefs. All of the briefs have been submitted and reviewed by this court, and we have determined that oral argument is unnecessary to resolve the question before us. For the reasons explained below, we conclude that neither a writ of mandamus nor writ of prohibition are appropriate remedies at this time. And then, yes, the writ of Matt Damon. The writ of Matt Damon. And then they go through their reasoning. I'm not going to go through it as in depth because I do want to get to questions and we need to get to the latest tweets with regard to BitBoy. But a lot of this was determined based on original jurisdiction. On November 13th, 2022, 4 University of Idaho students were found dead in their apartment in Moscow, Idaho. Brian Koberger was arrested and charged with the murders of the 4 students on December 30th, 2022. Koberger's case is pending in Latah County in the 2nd Judicial District of Idaho, is currently scheduled for prelim on June 26, 2023. The case has drawn widespread publicity, garnering worldwide media attention and much speculation. Accurate. Recognizing the high-profile nature of the case and the extensive coverage it has received, along with the need to minimize possible pretrial prejudice, Koberger's attorneys and the attorneys for the state stipulated to a non-dissemination order, footnote 1. Such orders, often referred to as gag orders, prohibit attorneys, parties, and witnesses from publicly talking about a pending case in an effort to prevent pretrial publicity from impairing the parties' rights to a fair trial. In this words are hard. In this opinion, we will use the term non-dissemination order unless gag order is used in the text of a cited decision. The order was signed by the presiding judge. This is the order. We've gone over it multiple times. We're not going to go through it. 15 days later, following an off-the-record meeting in chambers with Koberger's attorneys, prosecutors, attorneys for the witnesses, and victims' families, the magistrate court entered an amended non-dissemination order on January 18th, 2023 that expanded the scope of the original order. This amended non-dissemination order noted the need to curtail dissemination of information in the case and strike a balance between protecting the right to a fair trial for all parties involved and the right of free expression as afforded under both the United States and Idaho constitutions. And then they cite the amended order, which I've covered. Shortly after the amended non-dissemination order was issued by the magistrate court, a coalition of media companies, footnote 2, directly petitioned this court invoking our original jurisdiction and seeking the writ of mandamus and prohibition to vacate the order. These companies challenge the constitutionality of the non-dissemination order and seek an extraordinary writ to protect free speech rights and the media's ability to cover the case under the U.S. and Idaho constitutions. Notably, petitioners did not first file an objection with or seek relief from the magistrate court before filing their petition against respondents and the court. And that ends up being the problem here. The petition named the magistrate judge in the second district, and then they go on. Petitioners claim to date that there have been no notable leaks of or dissemination of extrajudicial information that would prejudice Kohberger's right to a fair trial. In their briefing, they present several situations that suggest the amended non-dissemination order is vague and overbroad. The court ends up deciding this, and I'm trying to find the heart of their decision on the original jurisdiction, because they found the parties had standing. Even if the parties have standing, it must have established that it has properly invoked the court's jurisdiction. This is the Supreme Court. So for the Supreme Court to have jurisdiction, you generally have either it wind through the court's process, the lower court's process, and then an appeal, or they have to have original jurisdiction. There has to be a matter that they can take up on their own before it is wound through the lower courts. And they're finding that's a very base level original jurisdiction discussion. They say the Idaho Constitution vests this court with original jurisdiction to issue writs of mandamus or prohibition, quote, and all writs necessary to proper and complete exercise of its appellate jurisdiction. Any person may apply to the Supreme Court for the issuance of an extraordinary writ or other procedure or other proceeding over which the Supreme Court has original jurisdiction. This original jurisdiction is limited only by the separation of powers provisions contained in Article 2, Section 1 of the Idaho Constitution and the court's rules. This is a discretionary power of this court. The writ of prohibition is not a remedy in the original course or in the ordinary course of law, but is an extraordinary remedy. And they go through the fact that these are not normal procedures, that these are extraordinary measures, and that it is well recognized that they are only used in extraordinary circumstances. Petitioners have not properly invoked the original jurisdiction of this court. The court's like, we don't have jurisdiction. We're not telling you what to do or not to. We don't have jurisdiction. We conclude the petitioners have not demonstrated the absence of an adequate, plain, or speedy remedy in the ordinary course of law. Take it up with the court that issued the shit. Take it up with the court that did this. In fact, the record establishes quite the opposite to be true. Petitioners came to this court first without seeking any remedy or clarification from the magistrate court that issued the amended non-dissemination order. Take it up with the judge who issued it. While petitioners have alleged that they had no opportunity to object, review, or otherwise participate in the decision-making process, because the judge, the record shows that they never formally objected to the amended non-dissemination order or sought clarification from the court. Moreover, petitioners have failed to show that seeking redress before the magistrate court would not provide an adequate, plain, or speedy remedy. Take it up with the judge. MB, yes, send it to Daryl. The Supreme Court was like, get the fuck out of here with this. Go sort it out amongst yourselves. So, in short, the media tried to call the manager, and the manager was like, no, deal with the court. Don't deal with us. We don't have jurisdiction. And so, in a very lengthy opinion, the court dismisses the petition. The gag order still stands. They have to take it up with the lower court. They have not done so yet. They may take it up, but they have not at this time. So that is the end of the petition. We're going to do a quick BitBoy crypto update, and then we will get to questions. For Hogue Law, send it to Daryl is a joke on Vanderpump Rules. I've watched so much Vanderpump Rules that I needed a haircut. That's exactly what happened. This is how my hair used to be like a side part with a bob. And I've watched enough Vanderpump Rules that I'm like, I miss my old hair. And here I've been influenced. I've been influenced. Let me see where this tweet is. Here we go. Let's do a swoop and then we'll get to questions. Quick BitBoy crypto update. Road so far on this is I have now covered this a lot. BitBoy crypto was ordered to federal court, didn't appear, has made a lot of allegations on Twitter and elsewhere about the plaintiff's attorney in a case with regard to influencers who have purportedly supported or promoted FTX and FTT before FTX went. It's alleged that BitBoy Crypto was one of them. He has said quite publicly he never took a sponsorship from FTX and was actually sounding the alarm that FTX was a problem early on. That seems to be supported by CoffeeZilla and others saying, I don't know if he ever actually talked about FTX. Some online have been like, no, he did talk about it once, but it seems that he was never paid to talk about FTX. This lawsuit against the influencers, I don't think is a super strong lawsuit. Is it the responsibility of Graham Stephan, BitBoy Crypto, and others that FTX went bankrupt? Was there any way that they would have known the way that the company was operating on the inside was seemingly illegal? And is it their responsibility? Is it Gisele Bundchen's responsibility? Is it Shaquille O'Neal's responsibility? This is a grouping of lawsuits with investors saying it's your fault. They're looking for where the money is. Plaintiffs are trying to find someone who has deep pockets because FTX is completely belly up and there is going to be way more people that have been hurt than people who haven't been hurt. Food Daily made a really interesting comment in the chat saying Taylor Swift knew. Taylor Swift did not know that FTX's internal operations were a problem. Taylor Swift knew that this was probably an unsecured security, which is two separate issues. And I think it's smart that Taylor Swift said, is this a security? Because Taylor Swift, I don't think was worried about this company imploding. Taylor Swift's questions were more along the line of Kim Kardashian getting fined for promoting an unsecured or promoting an improperly promoted security. Those are two separate issues here. This is being sued over the investors investing and then losing money. This is not the FTC saying, hey, you promoted something improperly. You didn't. I think there's still an argument with regard to the FTC. Different case here. I think the FTC argument is a much stronger one. Hey, y'all were promoting something improperly because actually you needed to disclose how much you were making. It was actually a financial token. All these things, those are all FTC considerations. This civil lawsuit is different and apart from that, if that makes sense. But yes, Taylor Swift asked the right questions and was like, I'm not touching that. I don't think Taylor has touched any crypto or monetary things at all. There's a lot of rules regarding promoting monetary investments and those types of things, and she knew to ask. So it's a different process. I think there could still be an issue with the FTC. We saw Kim Kardashian get fined like $1 million for promoting an unregulated token that's actually a security. So with that, separate. But Taylor asked the right questions because she has questions. Now, all of that to say, Ben Armstrong, BitBoy Crypto got sued and started going after plaintiffs' counsel. Plaintiffs' counsel said that he was threatened and that he was afraid. And we covered all those motions in other content. BitBoy Crypto didn't show up on the original court date and then showed up on the following Monday and gave an explanation. And the court talked about the fact that he read a statement out on the record. And I said in my video, I wonder what that statement is. Well, after that video, BitBoy Crypto released the statement that he read on the record on Twitter in response to my video. So thank you for that transparency. BitBoy Crypto said that he is going to release the transcripts when he gets them. Great. It'll be great to see. I'm interested to see the transcripts. But BitBoy Crypto did release the statement that he says he read on the record and said that maybe it was not quite this statement, but we're going to take a look because this is the statement that seemed to be at least somewhat persuasive to the court. I'm sure there was a strong advisement by the court that you have to be in court when the court orders you, and you cannot make any more statements about plaintiff's counsel. But with that, let's go look at what happened over on Twitter, and then we will move on. It's always a problem when I pull up Twitter. I'm like, I don't want to get sucked into whatever's going on. Ben Armstrong tweeted at me, really enjoyed your video. Thanks. The piece everyone is missing is that my opponent lied repeatedly to the court. And if that's proven, that's a big problem. I never threatened him or called him. In my original video, I believe when I was looking at the calls, I said, how do they know where all these calls are coming from? Runkle the Bailey said, sounds like he's still making comments about plaintiff's counsel. Yes. But he was told not to threaten, harass. There were a few other languages. But yes, this is still talking about plaintiff's counsel. Here are my statements. While we wait for the transcripts, you'll understand why I was worried. This is the statement from BitBoy Crypto that he says he read in court, mostly in sum and substance. Hello, Judge Damon. I would like to read a prepared statement and would be happy to answer any questions you may have. My name is Ben Armstrong, but I am mostly known on the internet as BitBoy Crypto. We are the largest YouTube channel for crypto in America. First, I would like to apologize for missing court last week. As you know, I had a scheduling conflict for a cruise with my fans to the Bahamas. I mean, at least he told the court what it was. A trip they paid a lot of money to go on to see me. I'm sure you also know I've been very adamant about not appearing last week. Yeah. I would like to explain my actions, or these actions. Great. When I received the summons, I forwarded it to my main lawyer, who is international, waiting on a response as to what to do. I don't know what that means. Does that mean the lawyer is out of the country? Does that mean they were traveling? Chat, you made a great point. He did not start it with, hey, motherfucker, I guess you do know who I am. I know. I know. It seems like a missed opportunity, but I don't think the court would have taken kindly to it. Meanwhile, we finally hired local counsel on Saturday. As you know, we were not even served until the 5th. And after meeting with a few other attorneys, the time simply wasn't there because Adam's team tried, this is plaintiff's counsel. Adam's team tried for weeks to deliver the summons to Arizona, a state I have never lived in. Well, that seems dumb. His business address is not hard to find. As you will see today, literally every single piece of evidence Adam has that says I threatened him with violence and made him feel unsafe is simply false, which is why I could not wait for this hearing. I've been like a kid on Christmas to clear my name, which we will demonstrate today. I mean, most of the clearing the name comes later in like your response to the lawsuit. But I guess with regard to whether or not there were threats, that happens now. Michelle M., if that's not in here, I'm going to be disappointed. Actually, I've read this. It's not in there, and I am disappointed. Your Honor, legalese is hard. So I apologize, and going forward, we won't have any issues as I now have representation to help me know what I need to appear at and what I don't. Legalese is hard, but when the court says shall, it means do it. For years, I have dealt with false allegations against me because I'm a very misunderstood and polarizing person, so I'm no stranger to having to defend myself against baseless allegations, as I will do today. Well, that comes later. I'm going to restate something I have said many times. I have never once picked up a phone to call him or his law firm. In fact, not only did I not do it, I couldn't have. My show was still live at 1:07 p.m. on March 17th. I have questions about all of this, and I would need to go back and juxtapose the two because I don't know if there are time zone differences here or not. There might not be. In fact, not only did I not do it, I couldn't have. My show was still live at 1:07 p.m. on March 17th. I then recorded videos until 1:49 EST. Okay, so maybe not a time issue because he actually clarified that this was Eastern time, and that's Florida as well, that we have proof of, and I brought signed statements from multiple people on my team that they were with me during this time. In fact, for the last call during the 5 o'clock hour, I was live streaming on my son's YouTube channel. Don't anyone tell my kid that BitBoy Crypto's kid has a live streaming channel. The way I will never live it down, my kid will be like, see, I should have a live streaming channel. No. Nope. Judge, I am aggressive when attacked. Well, okay. I can't deny that. Adam has placed me. I love that he just keeps calling plaintiff's lawyer Adam instead of Mr. Moskowitz. I don't know how the court felt about that. Adam has placed me on a lawsuit frivolously. He's attempting to fraudulently tie me to a company that looks like it may be the biggest scam in history. So yes, I have been angry. You did start your email with, "Hey, motherfucker." I have never had one single interaction with FTX or a marketing company representing them and have never received $1 from them. These defenses are for later. This hearing, this order to show cause hearing, and I get that he wants to like tell the court everything. The order to show cause hearing was literally just a why did you not show up? And I guess this is his way of explaining it, perhaps. But all of this goes in the motions that could have been filed in a motion to dismiss earlier and should be. We should see a motion to dismiss here. But I understand the frustration too of, hey, this is a bullshit lawsuit and I'm going to have to spend a whole bunch of money to deal with it. Cat Mom distracted me in the chat. Cat Mom, I'm going to ask my local Aldi. But I hear that Aldi got them for the summer. Just got home from the grocery store at Aldi. They have all dressed chips, bought 3 bags. He says he read this under oath. He did say that in his tweet that he read this under oath. And the court said that he read it under oath. Let's see. I understand this hearing is not about that. Oh, good. I should have just kept reading. Emily, keep reading. What the fuck? I understand this hearing is not about that. Well, good. We're all on the same page then. But it's important to understand why I'm so angry about this. But he's saying he's not threatening. He's like, I haven't threatened him. But the language he uses with the court is, I'm aggressive when attacked and I'm angry. Let's see. It's important that you understand why I'm so angry about this. Many people know me as the first person who warned people months before it collapsed to get away from it. FTX, I'm presuming. So my audience is angry too. Countless people messaged me and told me that I literally saved their life savings they had on FTX with my warnings. Frivolous lawsuits make people angry, and that's what this entire case is. I don't believe Adam is scared. I have never once threatened him with anything other than going after his legal license and after him for defamation after this is over. Bring the counterclaims. Adam and his firm have repeatedly denied our request to see the evidence he claims to have. He produced a call log and a paper copy of transcribed voicemails. That's not evidence. Let's hear the actual calls. There are probably close to 100,000 hours of my voice floating around the internet, so these voicemails, if produced, won't sound anything like me. How does he know that? But the piece I believe the court is missing here is, unlike Adam's family, my family has actually been attacked. My family was swatted in the middle of the night, which is fucked up. Don't swat people. I don't care how you feel about someone. I don't care what an influencer has done. Don't swat people. Any people. My family was swatted in the middle of the night, and the SWAT team members held guns pointed at me, my wife, my children, ages 7, 9, and 11. So I know what it's actually like to be threatened for real and placed in a position where my safety was at risk. That doesn't mean that Moskowitz doesn't feel at risk, because they are getting harassing phone calls. It might not be BitBoy Crypto that's doing the phone calls. It might be his audience or others. But his audience might be going after him, might be going after Moskowitz as well. He doesn't believe that plaintiff's attorney is scared. I don't know about that. We'll see. Because both things can be true at once, right? So I know what it's actually like to be threatened for real and placed in a position where my safety was at risk. And I share this to hopefully convince you that I would never do the same to someone else. You may be wondering why someone would do that to me. I don't know if the court's wondering. But if the court's not familiar with streaming and how the internets, then maybe it's good to explain. You might be wondering why someone would do that to me. The reason is simple. People make up lies about me every single day. People like Adam perpetuate those lies. He puts me at a much bigger risk than I ever posed to him. I mean, we're getting into I'm the one who's at more risk than him. He puts me at much bigger risk than I ever posed to him. I brought with me a list of tweets and replies a mile long of people threatening my family and saying way worse things about me than Adam has ever experienced. And that's why every day for me, and that's every day for me. It's every day, bro. Damn it. What a missed opportunity. It's every day, bro. Look, being a figure on the internet is not easy. And that's every day for me, and it's relentless. Frivolous lawsuits and false allegations have real consequences. They create echo chambers and attack vectors. What's an attack vector? That only breed more hate. I think that's what the plaintiff's attorney is saying that he's being subjected to, though. I think he's saying that he's being subjected to a hate vector as well, or an attack vector, whatever the fuck an attack vector is. And by Adam playing the victim in this courtroom without one single shred of evidence that I, Ben Armstrong, actually threatened him with violence, it's just a drama show for him. It's a clout circus. It's a clout circus. Runkle, I find this disturbing. Where is Runkle's comment? It just disappeared. Runkle said I get about one death threat per month. Runkle, I hate that. Who is threatening Runkle? Though I will say, I have gotten more death threats being on YouTube than I did as a district attorney, which surprises me. Still. Let's see. Attack vector, where are we? Okay, and by Adam playing the victim in this courtroom without a single shred of evidence that I actually threatened him, it's just a drama show. I'm hoping that we change that to a clout circus in the future for him, which is why he scheduled this hearing for when he knew I was going to the Bahamas. If that's true, that fact alone, if I am the court, that fact alone would also have led me to say, you know what, that's a problem. Because if plaintiff's counsel knew about the pre-scheduled trip and scheduled it on that day, kind of to spring a trap on BitBoy Crypto, that's not okay either. If he is aware of this trip, it is a problem for me. Because what it should be is, hey, I know that he will be in Florida on these days and this day getting back from the cruise. Can we schedule it then? We know he'll be in Florida then. He's within our jurisdiction. Scheduling it for when you know he's in the Bahamas to try to spring a trap is unfortunate. But if BitBoy had had a lawyer at that time, the lawyer could have said, Your Honor, we've received notice of this hearing. My client has a pre-scheduled work commitment and can be available on Monday, but not Thursday, but didn't seem to have a lawyer. There is a way to respond to this where procedure is followed. Shouldn't BitBoy tell the court that he can't show up? Yes, the court should have been advised. Absolutely. Absolutely should have happened. But he also seems that he didn't have a lawyer at that time, or at least his lawyer had not filed notice that he was the lawyer on the case at that time. But yes, BitBoy should have. Instead of taunting the court on Twitter, yeah, that was ill-advised. But it's also inappropriate for the attorney, if they know, to try to spring this kind of trap. It's not cool. So again, without vouching to the veracity of any of this, if true, then it says this information was all over our website, which he admitted in another filing that he and his team visited and combed through for evidence. This is exactly what he wanted. It's a setup, Your Honor. I mean, spring a trap, setup. Emily, keep reading. Adam lied under oath, and I am here today to ask you to please not allow these proceedings to continue. I will certainly do the same to help make that happen if Adam would be willing to cooperate. Thank you. So that's the statement. Excuse me. So that's the statement. And the court, we know that the court found essentially good cause and took the OSC regarding contempt off the calendar. And now we will continue seeing this hopefully just proceed in a more normal fashion where we will see motions from the defendants to dismiss. We've seen that in the celebrity case. We will do another FTX update at another time when we go through the celebrity and influencer cases. If the FTC picks up on any of this, I will be interested. That's really what I'm more interested in, is are we going to end up in a Kim Kardashian-like situation where Kim Kardashian didn't disclose the amount that she was paid and others Tom Brady, Giselle Bundchen, Shaq, whoever didn't disclose the amount they were being paid for these. I'm really interested in that. And I'm interested where this goes, with the influencers, because if you take a sponsorship and that company subsequently goes under, are you responsible for the people who bought the product or invested in the thing? That is an interesting question. Different than, did you do the sponsorship properly? I'm interested in that question as well. We're not there yet. But what responsibility does someone have? Like, what responsibility does Jennifer Aniston have if, smart water causes someone to get a rash? Well, she's like the face of smart water. But is it her responsibility if smart water has something happen down the road with their, mineral balance or whatever? Or if it's not actually water that makes you smart. Has anyone sued smart water? Because Red Bull doesn't give you wings. Does smart water make you smart? Has anyone sued over that yet? That sounds like a food court episode waiting to happen. So is it Jennifer Aniston's fault if you buy smart water and it doesn't make you smart? Right? So with all of that, at what point is it their responsibility? Right? All right. Is it Brooke Shields' fault if the jeans don't fit me? Exactly. Is it when is it? When is it the fault? So with all of that, we're gonna get to questions. You've got questions, I've got questions. And that's it. That's what we got with topics. I am tired. My brain is tired. We're 2 hours and 11 minutes in, and my brain is tired. It's time to get to questions, right? All right, let's get to questions. I've got questions. You've got questions. We've got questions. So we're gonna fuck around and find out. Since everybody else has fucked around today and not found out, we're gonna fuck around and find out. Hi, I got to move my screen so it's easier for me to see your comments so we can get to comments and super chats and all the things. It's good to see you. Law Nerds, thank you for being here. Thank you for the compliments on the hair. I don't know what's the part is doing its things today. We're trying to figure out how we style our hair, not a middle part. I don't know what happened here. Something's happening. We're just going to do this. Something is happening today. Something is happening. I'm here for it. It's all right. All right. Let us continue. Let us continue on to questions. You guys had great questions today. I know that we kind of interspersed them throughout, and I appreciate them. Pickle update. Oh, I need to put up the poll. I have not been feeling well. So honestly, after stream on Tuesday, I climbed into bed. I have not been feeling very well. So I did not put up the poll just simply because I have not been feeling well. Clout Circus by Fafau. We could use Fafau as like the FAO Shorts logo. I think there's room to make a Clout Circus. There's room for Clout Circus in all of this, which is fun. I need a Clout Circus shirt to wear to BravoCon. And maybe to VidCon. Oh, that would be fun. All right, let's get in Vid Summit. To all the cons, I need a Clout Circus shirt. Brandy Rose, question. Have you ever seen a judge ask the jury in a criminal trial if they have any questions for the witness before they're excused? I'm watching a trial and he's asked after every witness. Brandy, A, your hair looks fantastic. B, it does happen in some jurisdictions. It is not my preference as a prosecutor, but it does happen in some jurisdictions and with some judges. And so the jury will be told during jury selection, you'll be allowed to ask questions if you have them. And the judge will generally make some kind of a statement, like some questions we cannot ask the witnesses, or they might be improper because jurors might ask things that they can't know, like things that are hearsay or things that are improper evidence. But yes, I have seen that happens in some jurisdictions. That has never happened in a jurisdiction where I practice. And again, not my preference. So, but I thank you for the question. Lauren Adams said, I'm laying in the hospital post-op lumbar spinal fusion surgery. Cheers. Welcome. I hope your screws are well affixed and that you heal well. It is difficult. Get a squatty potty. It makes it easier. Back surgery is tough. So I'm lying in the hospital post-op lumbar spinal fusion. Thank you for help throughout this pain. Sorry for the losses in the community. It is, it's condolences to the whole community today, but my spinal fusion, I am so glad that I did it. Recovery can be a little bit long. Recovery is always a process. It will feel like you will never get back to normal again, but things will get better. But also a squatty potty really helps. Oh, and use cups to rinse your mouth because it's hard to bend over the sink when you're. I had like a 2-cup system for brushing my teeth after my spinal fusion because you can't bend over. And sinks are too low. I'm not a tall person, but having to bend way the fuck down to spit into a sink, I needed 2 cups. I mean, that's probably way TMI. My Cousin Vinny is free on YouTube Movies right now for anyone who hasn't seen it. Do that immediately. I mean, well, not immediately, after the stream, after you're done with this. Give me a few minutes and then go do that. My Cousin Vinny is so good. Question, I never understood what a prelim hearing is. Explain, please. I think I explained Alley Cat earlier in content, but just to circle around again, it is the first hearing before a defendant is held over for trial. So in the criminal process, there can be variations of this, but generally you have something that happens that is a crime. Then you have an investigation and or arrest and or both at the same time for that crime. Then you have an arraignment. Then you will have a determination hearing like a preliminary hearing. Other ways that that can happen is something happens at a crime, it's investigated, a grand jury is put together, and then someone is indicted. And then when they're indicted, it goes from indictment to trial. So it cuts out the preliminary hearing part because the indictment is the probable cause hearing. A grand jury hears the probable cause, makes the probable cause determination, and then an indictment is issued. Those things can be used in most jurisdictions. When they get used and how they get used is different. Like the feds almost always use indictment. I don't think I've seen the feds grand jury anything in a really long, or preliminary hearing anything in a really long time. The feds almost always grand jury. Grand juries are a little bit more secretive. Then you do the preliminary hearing, which is just a probable cause hearing. A crime happened. This is what connects the person to the crime. It happened in this jurisdiction. Hold this person over to trial. Because if you don't have the evidence that this person is more likely than not the person that did it, you shouldn't be holding them in custody till trial. And then cases get dismissed at preliminary hearing. It's fairly rare that it happens. Fairly rare that it happens. So then you get the preliminary hearing, then you get discovery and stuff, and then a trial, and then a judgment. And then if there is a conviction, appeals. If there's not a conviction, then it's acquittal, and off they go. So let's continue on. Rise Above. EDB, can BF force Idaho to pay travel expenses, lost wages, etc.? Also, can Idaho use the Uniform Act to force BF to testify? I am not on the top of my head knowing what Idaho's Uniform Act is. Can they force BF to testify? This is the procedure to do that with getting a foreign subpoena. Can they pay travel expenses? I'm not sure what the provisions are in Idaho, but often you can show hardship to have it quashed. And that's one of the hardships. Like I literally cannot get there. Travel expenses though are normally, hey, we'll send someone to come pick you up in a van and drive you. Do they normally do that? No, they don't. Sophia said, I'm a court clerk. We have to type these orders out manually, which can also lead to things happening. That's hard. But Sophia, thank you for the work that you do. It's really important work. And there are not nearly enough clerks in most courts. It's like, oh gosh, there's just not enough. Jenny said, I've been a prosecutor since December 2012, and the idea of putting a survivor through any proceedings that aren't 100% necessary is abhorrent to me. Well said, Jenny. I agree with you. And the fact that BF has to get an attorney and go to court and then fight in court is also one of those things that's just like, oh gosh. It's a lot of process. And Ain't So Plain Jane, question, will the defense present a case during the preliminary hearing, or is the burden with the prosecution? Burden is always with the prosecution. I don't know what benefit the defense has presenting a case, but it seems from the scheduling that the defense might present a case. Can you be impeached on what you say in the interview? Ebony, yes, you can. So on cross-examination, if something is different, yes, it can be brought up. It's like, you told us this, which is why there's generally a witness to it, like a defense investigator, because the way you would impeach someone if they say something different than what they said in an interview is you would bring in the investigator to testify. You were at this interview and you heard this conversation. Is this recording an accurate reflection of that conversation? And then you play the recording if there's a recording of it. And normally that's what people do. So yes, you can be impeached on that if you say something different later and it's proper grounds to impeach, like if it's actually really different. Question, if she identifies him, does she then become an accuser in terms of his right to face his accusers, or is it just the state? Ems, At trial, you have a right, you have a Sixth Amendment right. I think I got the amendment the amendment correct to face your accusers. I believe it's the sixth. I could be wrong. Chat, you can let me know. My brain is tired at the end of the day. But at preliminary hearing, that is not the case. So if it goes to trial, and if this witness identifies them, then, which I think is probably unlikely, then you would have to have that person come in and testify at trial, but not at preliminary hearing. At preliminary hearing, it's very common that law enforcement will come in and be like, and then we asked this witness who did it, and they pointed to the defendant's sitting over there. So you have the right to face the witnesses against you, which is why the witnesses come in at trial, which is why the rules against hearsay are what they are. You can't have somebody putting in a statement that's true to be used to find guilt against someone when that person doesn't come into court, except in very narrow circumstances. And so the rules of preliminary hearing are much looser and much different. Book Dragon said, listening to you while writing applications. I want to become a speech therapist. Good luck. Good luck. Good luck. Marmar said, sorry, had to pause. Now catching up. You never need to apologize. Do no harm should apply to all walks of life, not just the medical field. I agree. I absolutely agree. And you try, right? I think most people try not to be harmful. Not everybody, but I think a lot of people try not to be harmful. Tracy Peterson said in the chat, FYI, the Orchid Stanleys are already sold out. Did anybody see my orchid obsession that happened yesterday? I binge purchased Apple Orchid. I now have 2 different Apple Watch straps in the same light color of purple. My phone is that same color of purple. My pop socket that goes on my phone, not sponsored, should be, is also that same color of purple. I bought a new case and a new iPad, also both in purple. So if you don't follow me on Instagram, those are the things that you missed out on. I'm going to pronounce that wrong. Tree Cannon. I apologize. Your handle icon is absolutely lovely. I love how Emily talks about grieving. It would be awesome if she did a video with Ask a Mortician, especially since they're both Gen X ladies from LA. I have not watched Ask a Mortician, but I have heard a lot about their channel and all good things. So I will need to check it out. Grieving is something I'm well too familiar with, and it's still a process for me. We need a breaking news lights bumper. We might. I don't generally do breaking news. Maybe we need a new filing one, just because I don't generally do breaking news. But when there are new filings, sometimes we do. Oh, can our background music be your old intro music? Maybe my old intro music is the same intro music now. It's just a bit shorter. I forgot to do our StreamYard I Have Questions music. Damn it. Okay, hold on. I forgot to do it. Maybe we'll do this one today. Let's see. We're gonna vibe with the Feeding the Ducks one today. For our StreamYard I Have Questions background music. I totally forgot. Can we have Cloud Over Court merch? Yes. Maybe Judges Scales. Oh, that would be brilliant, Talia. Yes, it seems to be the theme of 2023. It does. Cloud Over Court, Clout Circus. Okay, but Clout Circus merch where it's a flea circus. I mean, maybe. Haven't caught a stream in a while. Well, Cincinnati Pondered, glad to have you here. Emily, your hair is absolutely gorgeous. Love the middle part. Thank you. I'm seeing how I feel. About it. It's new. I like it. I need to let it, I want to grow it a little bit more. But we're here. I love this idea. Clout Circus sponsored by FAFO. I think it's hilarious and everybody would know what it means. Love being able to listen to the live on my birthday, Michelle.
Happy birthday. I hope you're loving the vibes. Everyone else who has a birthday this week, happy birthday. It's Taurus season, my bulls. It is our time. Enjoy. It is our time. It is our season.
So to all my Taurian friends, happy birthday. It is time. Baron Wolf said, haven't been able to watch a live lately because life, I get it. That's why we leave the replays up. We're here. Can the professor appeal this decision? Gray 08. No, not really. I mean, could they? It would be a waste of time. It's a discretionary ruling by the court. And given all those factors, the court is not going to find or an appellate court is not going to find an abuse of discretion. There's not an abuse of discretion here. So it's not a word. Could it happen? Yes, it's not worth the money. Your mom, your birthday and my birthday are 1 day apart. So cheers. And Dr. B's birthday is May 5th. Mine is May 7th. So we are our birthdays. It's like, what are you doing for your birthday? It's like, well, it becomes a we. Like, what are we doing for our birthdays? Music to My Soul said my dog's name is Merit and his formal name is Meritorious. I'm pretty sure he wants to be excluded from this narrative. Yes, Meritorious is like, I want nothing to do with any of this. Taylor knew what questions to ask. Taylor Swift seems to have very good advisors. For sure. So let's see. Lux Luthor said, will Kohlberger have to plead guilty, not guilty at this preliminary hearing after? It seems to be what they do with that. I just wanted to say I love your hair. Thank you. Corny Roo, I appreciate it. L5S1, possible fusion candidate, sending healing. Yep, I've done that. It's not the most fun. My husband's birthday is the 6th. And our anniversary is the 8th. I love it. My husband's grandparents, his grandma's birthday was Valentine's Day. And they got married on Valentine's Day. So I used to give his grandpa a hard time. I'm like, so you wanted to buy one present for all of the romantic things. It is her birthday, it is Valentine's Day, and it is your wedding anniversary. I'm like, how did you get away with that? And I would look at her, I'm like, how did you let him get away with this, with everything on one day? And she's like, it's easy to remember. She was so sweet about it. I gave him such a hard time about it, but it was just so they're generationally appropriate. It was just like, it makes it all easy. I was like, come on. 3 days. But no, all on one. Happy birthday, anniversary, Valentine's Day. Love ya. It's good to see all my birthday buddies in the chat. There were 3 people on my high school swim team that all had the same birthday as me. I mean, I was one of the 3, so 2 others. And so it was fun because it was also always the week when we had swim finals. So swim finals always ended up being right at the beginning of May. So we always got to do swim finals and then do cake for all of us. There was only once that all of us in bathing suits eating cake with our hands devolved terribly, but most of the time it was really, even that was fun. It was really, really fun. Runkle, I love you, friend. Thank you for distracting. You're welcome. I know you need it. I know you need it. It is okay. I'm always here. You can just voice the rage in the group chat. It's fine. I'm here. We're here. Cause I know it's hard. What's the name of the Japanese band your son listens to? The Oral Cigarettes is one of them. There's a couple, but the Oral Cigarettes is the one whose name I remember the most because we talked about it here on the chat. Really, really fun, good music. So with all of that, we should go. Oh, Octo popped into the chat to remind me to do things I forgot to do. If you guys are new here, hi, don't forget to do the YouTube, likey, subscribey, all the things. But also if you want to stay up to date, there it is. Because we're going to make some shifts now that we're not going to be in New Mexico in May. Questions, what are swim finals? I was on swim team in high school, and so our like regional finals and finals going to CIF and stuff for California, I'm sure it's called other things elsewhere, like state finals for swim team were always that week. So there was always like 3 days to the 2 or 3 days to the best of my memory of finals for swimming. And I was never winning. I'm not a fast swimmer. It's why I liked water polo. I was not a fast swimmer. I did distance events and I was not good. I was passable. Much better at water polo than at swimming, but swim finals would always be that kind of end of May. And so it was like the end of swim season, the end of the school year, the birthday, it all felt very fun. We would do like big parties with our entire swim team at different parents' houses with pasta and garlic bread and all of the 90s like carbo loading thoughts, but it was really fun. Like that whole week of swim finals was really a good time. Those are some of my fondest high school memories with the fuck around on our swim team. Our water polo team and our swim team had a lot of fun. It made the hard parts of high school less hard, and it made a lot of it really, really fun. But we had parties at people's houses and did a lot of stuff together. And now I get to see my kid doing that with band too. So really fun to see. So that's what swim finals were. Me always cheering on my friends that did much better than I did. Because I was like, well, I like being on swim team. I like working out. I like swimming. And it keeps me in shape for water polo season. So that's why I did swim team. That was really the truth of the matter. And it was also nice to not to get to compete in the women's categories, as opposed to water polo, where by my senior year I was still 5'6", and everybody else was like 6'3", and I was like, this is not going well for me any longer. KJ said, I played water polo also. The water crowd is the chillest. They are. Aqua jocks are great. I also love band, all the things. So ADHD diving here as well. Look, water sports do well for us neurodivergents. We need to keep moving. I forget that now in my adult life. I forget how much moving helps me. But it's okay. Eventually I'll just have a pool and I'll get to go swim around in my yard. It'll be great. Though I think my idea of swimming now is more like floating and drinking a cocktail. I can still tread water though, so it's fine. It's all fine. It's all fine. All right. With all of that, you all, don't forget to sign up for Law Nerd Alerts. I will be back. I'm going to have to remember, how are we feeling about our music for our Q&A session? I like it. I feel like it kind of winds down our stream. It feels like a real good way to just ease into something different. And StreamYard gives us the music to do it. So I get to do it with StreamYard. I love that. So I feel like it's just, I like this one. This one's feeding the ducks. Night driving, we might have to try next week. I like it too. I like it. I'm kind of here for our wind down with the music. You guys all like it too. Good. Good. Thank you, chat. All right. With all of that, I've said with all of that 900 times. This is the longest goodbye ever. Today's Thursday. I am going to be off tomorrow, so I feel better. I will be recording the podcast probably on Monday for the members to do a behind the scenes. And then next week, I will be talking about some of the more trending topics. We'll go over what's going on with Elizabeth Holmes and some of the other stuff. Today, I just wanted to focus on this, and you can see why there was so much stuff happening today. Thank you for being with me. Thank you guys for parsing the facts from the fuckery. Thank you for being the best audience on the internet. I will see you soon. Hopefully we have an uneventful, restful weekend. I'm hoping to have an uneventful, restful weekend. Take care of yourselves. To all of you that are hit really hard with everything that's been going on and with the loss of those in our community and out, it feels like there's been a lot of recent passings of those who are beloved. So I'm keeping you all in my thoughts. Grieving is fucking terrible. It's the worst. And it drudges up friends from the past. And that's really hard too. It pulls it all together. So be kind to yourselves. Take care of yourselves. Don't push yourself. Give yourself some space and some grace. It's okay. It's all going to be okay. It's going to be fine. Giving yourself some grace and some space is not going to ruin anything. Take the time that you need. Big hugs from me, and I will see you in the next one. Thank you for being a Law Nerd.
You can find all the Law Nerd goodies at lawnerdshop.com. Connect with me on social media at the Emily D. Baker. And don't forget to check out my podcasts, The Emily Show, and the new podcast, Quick Bits, summarizing everything I talk about on my Tuesday and Thursday live streams. You know, when you only have time for just the quick bits.